their formal offer of documentary evidence, while the counsels for respondent Chief Justice Corona, also as directed by the court, submitted their comments, objections thereto on March 7, 2012. The impeachment court has ruled and made this representation read the dispositive portion of the ruling of the court.
Proceed. Please read the dispositive portion of the ruling of the court.
In view of all the foregoing, acting on the formal offer of documentary evidence of the prosecution and the comment objections of the defense thereto, the court resolves to admit Exhibits A to 7Os and Exhibits 7Qs to 10Ns of the prosecution, subject to the appreciation of the individual senator judges as to their weight and sufficiency for the purposes for which they have been offered. Further, the foregoing documentary exhibits are admitted as part of the testimonies of the witnesses who testified thereon. The tender of excluded evidence consisting of Exhibits 7Ps to 7Ps-7 is hereby disallowed for being improper, as these documents have already been excluded by the court because they tend to prove bribery, a crime not alleged in Article 3 of the Articles of Impeachment. The tender of excluded evidence serves no purpose because there is no appeal from the decision of this court. The prosecution is deemed to have rested its case, subject to its reservation on the presentation of evidence on the dollar account of Chief Justice Renato Corona, should the Supreme Court rule that the presentation of evidence of such bank accounts before this court will not violate the provisions of Republic Act 6426. The initial reception of evidence for the defense is set on March 12, 2012 at 2 o'clock in the afternoon. So ordered, March 12, 2012, Pasay Chief.
Your Honor.
Mr. President.
Majority Floor Leader.
Your Honor, please. Your Honor, please.
Mr.
Yes.
President, the prosecution wishes to be recognized.
Your Honor, please. May we just reiterate, Your Honor, that with the admission of our documentary exhibits as well as the testimonial evidence of our witnesses, Your Honor, the prosecution is resting its case subject to the reservation we have earlier made pertaining to the dollar account of the Chief Justice.
Yeah, well,
thank you.
just wait for the written resolution of this particular matter by the court, and you may make a comment or assert your reservation after you have read it.
Thank you, Your Honor.
Okay. Majority Floor Leader.
Yes, Mr. President, in compliance with the directive given by the presiding officer, the prosecution filed a notice manifestation confirming their oral manifestation that they have terminated the presentation of evidence on Articles 2, 3, and 7 of the Articles of Impeachment, and that they will no longer present evidence on Articles 1, 4, 5, 6, and 7. The prosecution submits that the impeachment court need not vote upon the charges in the above-mentioned articles. On March 8, counsel for Chief Justice Corona filed a motion to dismiss, seeking to dismiss the charges against the Chief Justice under the same articles with prejudice in view of the prosecution's failure to prosecute and present evidence in relation thereto. I move that the presiding officer rule on the motion.
Thank you. Regarding the motion of the defense to formally dismiss Articles 1, 4, 5, 6,
And 8.
and 8
Yes.
of the Articles of Impeachment, the impeachment court in a caucus decided not to act and not to entertain and act on the motion to dismiss. With the clear understanding, however, that no evidence from both prosecution and defense panels will be received by the impeachment court on Articles 1, 4, 5, 6, and 8, and furthermore, that the members of the impeachment court will not render any vote on Article 1, 4, 5, 6, and 8, and that no verdict of the impeachment court will be rendered on Articles 1, 4, 5, 6, and 8. So ordered. Majority Floor Leader.
Mr. President, the prosecution also confirmed their oral manifestation that they are reserving and not waiving their right to present evidence pertaining to dollar accounts of the respondent in connection with Article 2. On March 7, Counsel for Chief Justice Corona filed its opposition thereto, praying that the impeachment court deny the reservation to present additional evidence on alleged dollar accounts. I move that the presiding officer rule on the motion, Mr. President.
This matter has already been ruled upon previously by this court when we ruled on the suppression of the evidence involved. But nonetheless, I would like that the both panels will read the ruling of the court with respect to the admission of the offered evidence by the prosecution, as well as its ruling on the objections or comments filed by the defense on that offer of evidence. So ordered. Majority Floor Leader.
Yes, we are in receipt of a request for issuance subpoena ad testificandum et duces tecum to the Secretary General of the House of Representatives, several representatives, and the executive producer program manager of the news program Head Start of ABS-CBN News, or the official custodian of its news videos, to appear for examination before the impeachment court so as to their knowledge or personal knowledge regarding the verification of the verified impeachment complaint. I move that the presiding officer rule on the motion.
This is in connection with the ABS-CBN.
And also the subpoena for the House of Representatives and other representatives on the verification of the verified impeachment complaint, Mr. President.
Since the purpose of the subpoena is to present evidence on the circumstances on the verification of the articles of impeachment, which has been previously ruled upon by this court when it considered the motion for preliminary hearing filed by the defense, the request is hereby denied. Now, with respect to what else has been... Yeah. Majority Floor Leader.
Yes, well, all of the requests are denied, Mr. President, for the record, including the request for the ABS-CBN custodian. So, finally, Mr. President, on March 9, the prosecution filed its motion requesting that the defense panel be directed to manifest the order of its presentation of evidence in order to afford the prosecutors the opportunity to prepare for the reception of evidence of the defense. I move that, Mr. President, I move to submit the motion for consideration by the presiding officer.
Well, to be fair, in order to have an orderly proceeding, the defense is hereby ordered to comply. Majority Floor Leader.
Mr. President, we are now ready for the presentation of evidence by the defense.
The defense may now may now start presenting their evidence.
Your Honor, please, may we be allowed to be heard in connection with the rulings made by the Honorable Impeachment Court on our motion for the hearing on our affirmative defenses, Your Honor. We were made to understand, Your Honor, that the same is hereby denied, Your Honor.
Yeah.
We understood in the previous ruling of this Honorable Court earlier made, Your Honor, or promulgated, that what was denied is a preliminary hearing. And this is in conjunction with expediting proceedings, Your Honor. We were then satisfied that the introduction of our evidence, Your Honor, in connection with the affirmative defense shall be made in the trial on the merits of this case, Your Honor. And that we are prepared to do, Your Honor. We have subpoenaed, we have requested the appearance of our witnesses and also requested for the subpoena of our other witnesses, Your Honor. We have not received any final adjudication on the validity and or plausibility of the affirmative defenses we have set up in our answer, Your Honor. And this more particularly involved the existence, Your Honor, of probable cause and other matters in relation thereto, which nullifies the entirety of the proceedings being held by this court. We are charged with notice, Your Honor, that there may be some objection to this, because allegedly we have gone this far, but we are entirely hopeless, Your Honor. We have filed a motion for preliminary hearing that was denied, Your Honor. And our understanding of that denial is we are precluded from presenting evidence on the affirmative defenses at that time, Your Honor, but never at any instance before the case submitted for decision. Hence, we proceeded in participating with the trial on the merits, Your Honor. And there are so many instances, Your Honor, even in the ordinary court of justice, Your Honor, where a preliminary hearing on the affirmative defenses or a motion to dismiss or a demurrer to the evidence had been held in abeyance only to be resolved at the time or after the parties had been heard in a trial on the merits. That was our assumption, Your Honor. We have no reason to entertain the belief, Your Honor, much less concur with the present developments that our affirmative defenses had been totally denied, Your Honor.
Your Honor, I hope you understand our position. The rules governing preparation of the complaint on impeachment or resolution on impeachment is a function of the House, and that the function of trying and deciding the case is lodged in this court. Now, this particular impeachment case was filed under paragraph 4 of section 3 of Article 11, and I would like to read to the public and to this court the provision of paragraph 4. In case the verified complaint or resolution of impeachment is filed by at least 1/3 of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith begin. As far as this court understands this provision, there are two parts: that the complaint must be verified and that it must be filed by at least 1/3 of the House. If I remember correctly, and I have here, may I have the articles of impeachment?
Yung ruling na pinuha natin.
Is this the articles of impeachment? I have here the articles of impeachment. Republic of the Philippines, House of Representatives, House of Representatives Complex, Constitution Hill, Quezon City, in the matter of the impeachment of Renato C. Corona as Chief Justice of the Supreme Court. Representatives Neil C. Tupas, Jr., Joseph Emilio A. Abaya, Lorenzo R. Tanyada III, Reynaldo V. Umali, Arlene J. Bagao, and other complainants comprising at least one-third of the total members of the House of Representatives are indicated below. So there are 5 named congressmen. And as far as we can see, the articles of impeachment filed in this court has been verified. Now, where we have to ask all the members of that court, that prosecuting body, whether they read these impeachment articles of impeachment or not. That would be tedious, and I think that what was contemplated, as far as the understanding of this court, what was contemplated, that as long as 1, 2, 3, 4, 5, or 100 of those who filed this case verified this complaint, that is the verified complaint spoken of in paragraph 4 of section 3 of article 11. And so therefore, when it reached this court assumed jurisdiction, and in fact we have gone through trial already. The answers and reply to the answers have been filed, and we proceeded to trial. The prosecution closed its presentation of evidence. It's now the turn of the defense to present its evidence, and I think it is the opinion of this court that it's too late to raise the question of verification at this point.
If Your Honor, please, may we be allowed to say something on this particular issue, Your Honor.
Yeah, proceed.
The records will show, Your Honor, that right after we have filed our answer to the impeachment complaint, Your Honor, we have also availed of the remedy of filing a motion for a preliminary hearing on our affirmative defenses. We were then abiding by the jurisprudence on the point laid down in the case of Francisco et al. Versus House of Representatives, where it is stated that if there is a defect casting doubt or legality or violative of the Constitution on the part of the impeachment complaint, the same may be raised in the House of Representatives and also in the Senate prior or during the trial of the case. And if the Senate rules either way, then the remedy is with the Supreme Court. That was a dictum laid down in that case, Your Honor. Now, we were also guided by the fact, Your Honor, that in the same case, there was an adjudication to the effect that raising the issue of non-existence of probable cause goes into the very merits of the case, Your Honor. And as held by the Supreme Court in that case, Justice Panganiban speaking for the court, it stated that during the oral argument, may I be allowed to read for the record, Your Honor?
Yes.
Yeah, right. Senator Salonga and Petitioner Francisco Chavez denounced the second impeachment complaint as violative of due process. They argued that by virtue merely of endorsement of more than one-third of the members of the House of Representatives, the Chief Justice was immediately impeached without being afforded the twin requirements of notice and hearing. In here, Your Honor, the complaint was filed by more than one-third, Your Honor. The proceedings were therefore null and void ab initio. And Justice Panganiban, who was then the Chief Justice, I must agree. The due process clause enshrined in our fundamental law is a condition sine qua non that cannot be ignored in any proceeding.
Just a minute. The proceedings of which body, the House or this court, is going to be
this court
is supposed to be null and void?
Yes, Your Honor, including the proceedings before this court, because there is not the the impeached public official is not precluded from raising the same issue before this Honorable Impeachment Court, Your Honor.
Well, this is a variant of opinion between the defense counsel and this court, because then if you insist that we will make a finding of probable cause as a consequence of determining whether there has been a probable cause in the articles of impeachment submitted to this court, then we will make a ruling to that effect.
It's not that a ruling, Your Honor, on the existence or non-existence of probable cause is being asked by this representation, Your Honor, but it is a matter of fact that there was no determination of probable cause. In other words, there were no evidences, there were no allegations that will prove the existence of probable cause. And yet, the public officer involved was immediately impeached. Supreme Court said that is violative of the right against due process, because due process requires notice and hearing. And it applies in all cases, notwithstanding the fact that this is a proceeding which is sui generis, Your Honor. And the Supreme Court went further, Your Honor. Due process clause enshrined in our fundamental law is a condition sine qua non that cannot be ignored in any proceeding, administrative, judicial, or otherwise. It is deemed written into every law, rule, or contract, even though not expressly stated therein. Hence, the House rules on impeachment, insofar as they do not provide the charged official with notice and opportunity to be heard prior to being impeached, are also unconstitutional. We are predicating our action on this particular provision, particular statement of the Supreme Court, Your Honor. In addition thereto, likewise, the Honorable Justice Santiago, in a concurring opinion, likewise stated, and may we be permitted to place it on record, Your Honor?
Yes.
The impeachment complaint suffers from yet another serious flaw. As one of the amicus curiae, former Senate President Tobito Salonga pointed out, the signing of the impeachment complaint by the purported one-third of the congressman was done without due process. The Chief Justice, against whom the complaint was brought, was not served notice of the proceedings against him. In here, likewise, what is referred to is an impeachment complaint filed by at least one-third of the members of the House of Representatives. And the Supreme Court, going further, stated, no rule is better established that under due process clause of the Constitution than that which requires notice and opportunity to be heard before any person can be lawfully deprived of his right to be heard, before any person can be lawfully deprived of his rights. Indeed, when the Constitution says that no person shall be deprived of life, liberty, or property without due process of law, it means that every person shall be afforded the essential element of notice of any proceedings. Any act committed in violation of due process may be declared null and void, Your Honor.
Is it the position of the defense counsel that indeed there is no probable cause in this case?
That is our position, Your Honor. And if we were allowed during the early days before the evidence of the reception in chief, Your Honor, we would have done so right at that moment. We seem to be ported.
But you see, under our rules of impeachment in this Senate, we do not have a provision governing preliminary hearing on defenses in impeachment cases.
Yeah, but that was...
And we are authorized by the Constitution to devise our own rules of impeachment. This is not rules that the Supreme Court can formulate for this House. It is the formulation of this House itself.
We are in total conformity with that, Your Honor. We are likewise in full accord with the said pronouncement of the Honorable Presiding Justice. But what we are invoking is the right of the impeached public official, in this particular instance, the Honorable Chief Justice Corona, to his right to due process. And the right to due process recognizes that it is available in all kinds of proceedings, including impeachment proceedings, Your Honor. It does not exempt impeachment.
Must the must the determination of probable cause be done by the House of Representatives, or could it be done by this court?
It may be done, Your Honor, by the House of Representatives, and any ruling by the House of Representatives may be brought before the Senate Impeachment Court if the opportunity so arises. And a ruling thereon may be made, either a denial or a grant, Your Honor, in which case judicial remedies are afforded in favor of the aggrieved party if there is an abuse of discretion that brings about the power of judicial review on the part of the Honorable Supreme Court, Your Honor.
The Majority Floor Leader.
Yes, may we recognize Senator Miriam Defensor Santiago, Mr. President.
The gentle lady from Iloilo.
Mr. President, may I offer the humble submission that in my view there is no constitutional issue involved. There is no constitutional issue of due process or equal protection. Instead, there is a specific rule in our rules of court, Rule 16, Section 6, which is entitled Pleading Grounds as Affirmative Defenses, and it quotes in part, "If no motion to dismiss has been filed, any of the grounds for dismissal provided for in this rule may be pleaded as an affirmative defense in the answer, and in the discretion of the court." I would like to emphasize this phrase. In the discretion of the court, a preliminary hearing may be had thereon as if a motion to dismiss has been filed. The annotations based on jurisprudence indicate that unlike a motion to dismiss based on the failure of the complaint to state a cause of action, which may be resolved solely on the basis of the allegations of the complaint, a motion to dismiss raising an affirmative defense that there is no cause of action as against the defendants poses a question of fact that should be resolved after due hearing. Therefore, the issue is really whether the defense is there is no cause of action as against the defendants, and the question is a question of fact. Then, in that case, a hearing in the proper discretion of the court might be ordered, but otherwise, it is completely discretionary with the court. A party effectively submits to trial court's jurisdiction by praying for the dismissal of the complaint on grounds other than lack of jurisdiction. So, just to repeat to summarize, granting a hearing on a ground alleged as an affirmative defense is, as the rules say, in the discretion of the court. That is my comment.
Counsel, you are not questioning the jurisdiction of this court.
If there is really no probable cause, Your Honor, and therefore the impeachment complaint is a total nullity, then there could be no jurisdiction that the Senate Impeachment Committee can acquire, Your Honor.
If the issue of probable cause could be decided on the prosecution side as well as in the court itself, this is my understanding of the rule in the ordinary courts, in criminal cases.
We appear to be quite insistent on this particular matter, Your Honor, because we have sought guidance from the jurisprudence of the Honorable Supreme Court in connection with this matter. More particular, the point that whether probable cause could be raised even after the remand of the impeachment case to this Honorable Supreme Court.
But in the case of Francisco, the articles of impeachment has not reached this court. The case arose out of the proceedings in the House of Representatives, and so therefore the Francisco case is not on all fours with respect to the factual situation in this particular impeachment.
That's correct, Your Honor. But it is a guidance, since there is no categorical provision under the rules of impeachment of the Senate Impeachment Committee. Many times we are at a loss, Your Honor. Here is a problem. We wanted to argue either against or for, but there is no definite provision under the rules of the Senate, Your Honor. So where do we go?
Do you know why it is like that, Your Honor? Because there is no appeal in the decision of this court.
Yes, Your Honor.
There are no reversible errors. There are no assignment of errors. Once a verdict is pronounced of acquittal or conviction, if it's acquittal, the government cannot appeal. If it is conviction, the respondent cannot appeal. There are no assignment of errors. There are no reversible errors. That is the reason why in an impeachment trial, as far as I know, there is no motion to dismiss. There are no motions for preliminary hearings. That's why the Constitution says trial shall forthwith proceed. It did not say begin. Proceed. Go ahead and try it and all the way to judgment. Except that you have to respect the rights of private parties that may be involved.
Well, we were this insistent, Your Honor, because we are worried about the resulting consequences of the aforesaid pronouncement, Your Honor, with due respect to the Honorable Court, on the impeached public official, Your Honor.
All right.
We have here a portion, Your Honor, and before we are considered terminated in our argument, Your Honor, may we read it for the record, Your Honor.
We will understand your position. If you want to read your argument, go ahead.
The question on the sufficiency of the complaint in form may again be brought to the Senate by way of proper motion, and the Senate may deny the motion to dismiss the complaint depending on the merits of the ground raised. After the Senate shall have acted in due course, its disposition of the case may be elevated to this court pursuant to its judicial power of review. So we are referring to a situation where an apparent grave abuse of discretion existed on the part of the impeachment court.
What this court wishes to avoid is a clash between the Supreme Court and this court. Because, frankly, I must say that this court is not willing to surrender its power to make a judgment in impeachment cases. And so, if the decision of this court with respect to the existence of probable cause is reviewable by the Supreme Court, then, in the opinion of this presiding officer, and I think as well as of this court, that will mean that the Supreme Court will override the judgment of this impeachment court. And so, therefore, with most regret and with due respect to the Supreme Court, we will deny any interference in the judgment of this impeachment court.
Mr. President.
Well, trial suspended. I will consult the members of the court.
Thank you, Your Honor. Thank you, Your Honor.
Mr. President.
Suspendido na ho muna ang trial at kasama pa rin ho natin si Rowena Daroy Morales. Okay, pag-usapan ho natin kung ano yung mga pinag-argumento nila dito sa impeachment court. Ito yung punto nga ni Justice Serafin Cuevas.
Siguro bago tayo umabot doon sa meat, no? What just happened? I think a lot of the members of our audience, parang, what's going on? What's happening? Mismo, nagtataka. Akala ko ba magkakaroon na ng fireworks? Maririnig ko na kung ano yung depensa. Anong klaseng depensa to? In the first place, siguro pag-isapan natin yung ano ibig sabihin ng affirmative defense na pinipilit ngayon ni Justice Cuevas na gagawin dapat nila ngayong umpisa, uli. Or rather, umpisa uli ng trial kung saan sila ngayon ang magpipsita ng ebidensya. Okay. May tinatawag tayo ng affirmative defense. Hindi po ito yung tinatapatan kung ano yung mga bintang o kung ano yung charges, kundi it goes into, meron silang sariling argument.
Hindi igutan ba?
Hindi naman. No? Mawawala sana itong question na to. As in fact, siguro mawawala yung question ng marami pang mga nakaraan na mga controversy kung nagkaroon nga ng preliminary hearing.
Yes.
Nabanggit nga ni Senate President na wala sa rules ang preliminary hearing. Pero siya na rin ang nagbanggit na pwede silang gumawa ng kanilang rules and sa discretion nila to make things easier. Di ba? Hindi naman sinasabi sa rules nila na hindi pwede. Although hindi nakalagay na pwede.
Na pwede rin.
Which means na pwedeng, sige, let's make things easier. ano nga yung mga dapat na i-mark dyan? Kung may preliminary hearing. Ito importante sa preliminary hearing, yung tinatawag nating affirmative defense. Ano yun sa kasong ito? Meron bang cause of action? Isa yung tinatanong, ano ba ibig sabihin ng cause of action? May nabanggit si Justice Cuevas, determination of probable cause. Una pang criminal case yan, ano? Pero yung cause of action, ano ba yung cause of action? Ang cause of action is a commission or an omission. Commission of an act or the omission, meaning hindi nagawa, that constitutes a violation of law. Ito, usually ay nakikita sa complainant na mismo. Kahit hindi mo natignan, kahit wala pang ebidensyang pinipresenta, kahit hindi pa naglilitis, ayon pa lang sa mga nakasalang or nakalista doon sa complaint, makikita mo, ano yung ginawa? That constitutes an offense. Ano yung ginawa? That constitutes an offense. Dito, 8 yung sinasabi. Kaya nga meron tayong 8 articles of impeachment. Kaya lang, 3 lang. In fact, 2 lang yata ang sinasabi nila na nalabag. Yung culpable violation of the Constitution at saka yung betrayal of public trust. 2 sa mga grounds for impeachment. At paano nagkaroon ng ganito? Ito nga yung mga ginawa o hindi ginawa. Yun ang magdidetermine kung may probable cause na tinatawag o hindi. Cause of action. Kung wala kasing cause of action, pwede nang i-dismiss yung tinatawag na motion to dismiss. Kaya lang hindi rin pwede sa impeachment trial yung motion to dismiss. Ang ibig sabihin kasi ng motion to dismiss, ay naku, questionin mo, ang dami-daming mga grounds yon. It's a very technical thing. Sige, this is a political exercise anyway. Gustong malaman ng sambayanan, ano ba itong mga bintang na to? So hindi siya parang
regular court, no?
Correct.
Diba? Yun yung gusto mangyari ni Justice Cuevas. Pero since day one, naalala namin, ito na yung kanyang argumento nung na-deny yung preliminary hearing Professor. At pili niya kinukumpara ito dun sa resolution ng Supreme Court, dun sa Davide case, na hindi naman umabot nga ng Senado.
Correct.
Diba?
Correct.
So sinabi na rin dati ni
Chief Justice.
Chief Justice at yung panganiban dito na hindi maaaring ipagkumpara ni Justice Cuevas yung Davide case dito sa Corona case. Dahil ito'y dumaan sa ibang proseso ng impeachment eh. Yung Davide case, public hearing. Yung Corona, 188 na. Kaya diretso na sa Senado.
Kasi yung sa Davide case, ito yung sa Francisco case actually,
Francisco
involving the
case.
Davide impeachment, ang nag-file ng complaint, individual. Alright? So, kinailangan i-refer sa committee.
At
Na kailangan
sponsor ng
magkaroon ng
congressman,
dinig.
Kasi may parang
ng
ulitin mo
pandinig.
natin na may shortcut tsaka may long cut na paraan na pag-file nitong impeachment complaint. Yung unang paraan is that ang congressman or private individual i-refer itong complaint nila doon sa Committee on Justice ng Congress, no? At saka kung medyo marul na sufficient informant substance, didiretso na ito doon sa Senado.
Okay.
Ang medyo shortcut naman ho nun, yung 1/3 ng House, kung pipirma, in this case, 188, ang dumiretso na siya sa Senado.
Sa totoo lang, hindi shortcut yun. Alright?
Isa
Those
sa mga
are 2 independent ways. Kasi pag nag-file ang isang individual, you, me, anyone can file an impeachment complaint as long as it is verified. Ang ibig sabihin ng verified, sumusumpa siya na totoo. Yung kanyang mga sinabi doon na acts or omissions nga that would constitute grounds for impeachment. Pero kung individual ang magpa-file niyan, pupunta pa yan doon sa committee. At pagdating sa committee, magkakaroon pa yan ng pandinig. At saka kailangan makuha pa yung yun kaya siguro sabi mo, long cut. Kaya may naging shortcut, dumiretso sa 1/3. Ay, teka muna, mga ano na yan mga representatives na yan. Hindi ba? Correct. Yun na yung articles of impeachment kung ano na yung complaint nila.
Okay.
So ano nang nagiging strategy ho nila rito? Ipakita na hindi properly verified.
Ang gustong sabihin ni Justice Cuevas nga, wala daw cause of action. Therefore, walang due process. Wala daw due process kasi hindi nadinig. Or wala kasing paglilitis o pandinig sa House of Representatives para pumunta sa second stage, which is the Senate. Pero hindi kailangan yun Hindi kailangan yon kasi nga 188 na, more than one-third.
Pumirma.
Correct.
Oo.
So, hindi na kailangan ng tinatawag nating yung hearing na yun sa House.
Kasi ang inaasahan ng publiko, o depensa na, so sila na magpipresenta ng ebidensya at witness. Pero nung biglang na-question na naman itong teknikalidad, mukhang, hindi ba nagle-lay down lang ng premises, Professor, para sa pagharap ng kanilang mga witnesses, questioning yung mismong articles of impeachment, di ba, na minadali at hindi ito kumpleto para ma-impeach ang isang punong maestrado? Hindi ba ganon?
From what I understand sa sinabi ni Justice Cuevas, it appears like there was a motion to conduct a hearing on the affirmative defenses na na-deny. At ang pagkakaintindi niya, yung denial was the hearing on affirmative defenses during a preliminary hearing. And alam naman natin na hindi talaga nag-deny ng preliminary hearing. So dapat daw bigyan sila ng pagkakataon dito. Sinasabi ni Justice Cuevas, wala daw due process. Dahil walang notice. Ibig sabihin,
yung nireklamo, yung kinasuhan.
Hindi daw binigyan ng notice si CJ tungkol dun sa complaint na yon. We understand, alright? The due process has something to do with opportunity to be heard. Ito yun eh.
Ayan na.
Diba?
Pero bago nag-umpisa impeachment trial, sinagot ho ni CJ Corona yung every articles of impeachment, di ho ba? Kaya may kopya na rin sila nung sagot. Ibig sabihin, pinasok na rin niya yung sarili niya sa proseso.
Sumagot sila. Talaga, answer to verified complaint for impeachment 12 December 2011. Sumagot sila, kompleto. Ang kapal. No? So, hindi ko maintindihan ngayon bakit sinasabi nila na parang hindi sila nag-participate. Ngayon, ina-expect natin, nasaan na ngayon yung evidence at yung proof para patunayan yung mga nilagay ninyo dito. Kagaya ng pagpapatunay na pinakita ng prosecution dun sa mga nilalaman ng kanilang verified complaint.
Kasi depensa mismo ang nagsabi na handa tayong sagutin lahat ng yan, isa-isa, punto por punto. Pero ngayon, parang napupunta tayo dito sa ibang strategy na ipakita na depektibo nga itong complaint na
teknikalidad.
I am not saying I am surprised, no? Kasi yung
trabaho ng depensa
na ganito ang gagawin nila. Kasi puno yung mga dyaryo na ipipresent daw nila, 3 representatives. Natitistigo na hindi daw nila nabasa.
Itong yung Mandanas, Toby Tiangco, and Crispin Remulla dahil raw hindi sila bumoto doon sa articles of impeachment.
Kasi hindi daw nila nabasa. Hindi naman nila nabasa daw, hindi dahil sa ayaw nilang basahin, kundi hindi sila binigyan ng pagkakataong magbasa. Kung hindi daw nila nabasa yon, therefore, hindi rin nabasa daw ng mga ibang naglagda ng kanilang pirma doon.
How are they so sure na hindi nabasa ng iba?
Eksakto.
May PowerPoint presentation eh.
May mga numbers pa eh. Yung numerical probability.
At bakit sinasabi naman na maaari rin ipatestify rin itong mga prosecution lawyer, Miro Kimbo, Rudy Fariñas, ano naman ang maging papel nila dito sa testimonya para sa depensa?
Sa totoo, hindi ko alam kung bakit sila gustong
Si Congressman Fariñas, hindi pumirma. Pero kasama siya ng prosecution panel.
Correct.
Si Miro Kimbo pumirma.
Correct. Siguro tatanungin, nabasa mo ba bago ka pumirma? Maybe the same thing. After all, kaya may tinatawag tayo sa PINA kahit ayaw mo.
Kung hindi nga binasa,
ano yung pinirmahan mo?
Kung let's say, medyo nag-speed reading lang. Sige, pwede na to.
Naintindihan na nila.
Di ba may sinasabi ho na, tulad nung sundan ko lang kay Vicky na, pag hindi nabasa nung isang nagre-reklamo, yung kanyang reklamo, ito ay mayroong violation ng batas sa ordinaryong korte, hindi sa impeachment court. Tama ho ba?
Sa totoo lang, there is a presumption na binasa mo. Kasi ang intelligent person at matatalino naman lahat ng ating mga representatives. Palagay mo, ipipirma at ilalagda nila yung kanilang katauhan through their signature. Sa napaka-importanting bagay na hindi nila alam ang laman, pwede naman kasi.
They don't necessarily have to.
Hindi mo binasa word for word, pero alam mo kung ano yung laman.
Yes.
Or in-explain sa'yo. Pwede rin naman yun eh. And it can be explained to you. Kagaya nga dito, may PowerPoint presentation. Ladies and gentlemen, ito ang laman ng complaint.
Di ba? Anong pipirma natin? Impeachment ni Chief Justice. Bakit?
Ando doon dapat.
Di ba nandun yun? Oo.
But they don't necessarily have to agree with everything in the articles of impeachment.
They have to.
Lahat-lahat.
Dahil wala namang conditional, pinipirmahan ko, pero hanggang dito lang.
Pero
ito lang.
except article
Lahat.
ganito.
Wala. Lahat.
Pero sa rules sa impeachment, the mere fact na nilagay mo na yung lagda mo doon, na kumpleto na daw yung proseso eh.
Well, totoo, because
oo.
they reach the numbers. 1/3 lang ang hinihingi. Lumampas pa. Diba? So, hindi na kailangan ng tinatawag nating hearing sa committee level.
Paano yan kung humarap itong mga House prosecutor na nga dito para sa defense at pagtetestingan sila ni Justice Cuevas, bigyan sila ng oral exam at hindi nila masagot. Does that mean hindi nila binasa yung complaint?
You know what? Ito lang ang akin. Sabihin natin, yung mga testigo na ihaharap nila, hindi nga nagbasa. At, hindi ko alam yung nilagda ko. Yung mga iba, nag 1/3 pa din. Ano yun, sinasabi ba? Umaatras sila? Yung mga naglagda. That could be an implication. On the other hand, ano yan? Gusto mo lang pahiyain na, sige, bigyan kita ng exam sa binasa mo. Tama ba yun?
Parang approve without thinking. Ganun ba ang dating?
We presume they approve because they thought, they understood,
At
and they knew
naniniwala
the
sila.
implications.
Ayan na si Tubit Yanko, nakikita natin sa video. Medyo nagre-ready na siguro siya. Pero ito,
Flexing the muscles.
hindi na siya sinapina, no? Talagang
Nag-volunteer.
pusa siya talagang humarap
Si
dito.
Congressman Remulla gusto niya pasabpi na siya.
Pero itong mga House prosecutor, are they obliged to testify?
No, in much the same way as Justice Sereno. Sabi nga niya, di ba? Kahit may sabina o wala,
Yung judicial
mag-testify siya.
privilege.
Okay.
That's right. Kaya nga lang naging moot and academic. That's why may question kanina regarding Representative Chongko?
Tiangko.
Toby Chanco.
Chanco, all right.
Oo.
Na sabi ni Representative Gonzales, sana naman niya wag niyang ipahiya. Bakit?
Ang institusyon.
So there was a little binabalaan mo ba?
Tinitreaten niya. Okay. Balikan po muna natin si Joseph Morong sa Senado. Joseph, anong latest?
Okay, nasa loob pa rin yung mga senador, no? Pero bago sila pumasok, well, at least majority of them yung nasa loob. Kasi nung lumabas ako kanina, nasa gallery rin, nasa loob ng session hall pa rin itong sila Senador Miriam Defensor Santiago, Senator Pia Cayetano, Senator Joe Arroyo. So, aside from those three, yung lahat nasa loob na, no? Anyway, before sila pumasok sa loob, maliwanag yung sinabi nitong si Senate Presiding Officer Juan Ponce Enrile na they will not surrender yung kapangyarihan ng Senado to try impeachment cases. Bakit niya nasabi yan? Kasi ang ginagawa ng depensa ngayon ay sinusubukan nilang bumalik dun sa square one, no? Nung ating pagdinig noong day one, ang sinasabi nila walang probable cause, therefore walang basis itong impeachment complaint laban kay Chief Justice Corona. Ang sinasabi ng Senado is that yung trabaho ng pag-establish ng probable cause ay hindi sa Senado ginagawa because according to the Constitution, ang kailangan lang gawin ng Senado is tanggapin yung impeachment complaint na manggagaling sa House. So, yun yung basis ng unang pag-deny ng Senate dun sa hearing for preliminary motion for preliminary hearing ng defense. Ngayon, ang logic kasi nitong si Senate Presiding Officer Enrile is that kung gagawin natin yung pag-determine ng probable cause, ay magiging bukas yung Senate doon sa review powers ng Supreme Court. Kasi ang sinasabi nitong si Defense Lead Counsel Serafin Cuevas is that the Supreme Court may be able to review yung magiging finding ng Senate. Ang ayaw mangyari yan ng Senado, Igan. At sinabi nga ni Senate Presiding Officer, we will stick to the power of the Senate to try impeachment cases according to what the Constitution has envisioned it to hold. Igan, Vicky.
So, ibig sabihin, pag sa impeachment trial, anumang desisyon nila, hindi na dumadaan sa anumang pagrebisa ng kataas-taasang hukuman. Mababaliwala yung intensyon ng impeachment eh.
Kasi parang this is yung sinasabi nating konsepto na sui generis, no? Parang pag yun ay binagbigyan mo na isang halimbawa yung Supreme Court will be able to review the actions of the Senate as an impeachment court, parang ano pang magiging kapangyarihan yan kung laging subject to review. So parang walang appeal na motion or walang appeal na recourse yung mga nasa loob niyan. Pag sinintensya na halimbawa itong si Chief Justice Corona, kung ano man yun, ay hindi yun pwedeng i-apela and that will hold.
Tsaka wala sa isa yung public accountability. Kung guilty sa impeachment court, tas under review pa pala, paano pag nagkaroon ng reversal ng decision?
Tama yung pwede yung ganyang analysis, no? Parang ma-invalidate yung power na ibinigay ng Constitution dun sa impeachment court if that will happen.
Kaya nga pag guilty,
Guilty lang
tanggal
yun.
sa pwesto pero tuloy ang mga posibleng kasong administratibo at kriminal.
Ang
Diba?
sinasabi is na punishment do sa impeachment court, quote-unquote punishment, is that you will be removed from office.
From office.
As to whether you will be filed a criminal case, ay walang sinasabi dyan. Pwedeng gawin yan outside of it, pwedeng gawin ng ibang tao yan. Pero ang pinakaparusa ng impeachment ay tatanggalin ka sa pwesto.
At perpetual disqualification yata sa anumang posisyon sa gobyerno.
Oo, pati yung mga, yung tatanggapin sana ng mga, ang tawag mo doon pag nag-retire ka?
Alin?
Mga benefits?
Wala na
Retirement benefits,
tatanggapin.
wala na yan.
Oo.
Joseph, dito kay Representative Tiangco, sino pa ba ang inaasahan nating tatayo dito sa witness stand? Kung darating tayo sa puntong yon.
Okay, kung makakatawid tayo sa issue na yan, no, at dumating tayo sa presentation of witnesses, si Representative Tiangco kasi volunteered, no? But yung defense wants, I think, 2 more. Itong si Representative Mandanas and si Representative Remulla. But si Representative Mandanas, sabi niya, ay haharap lamang siya sa impeachment court kung may subpoena. But then we know na ayaw magpalabas ng Senate. Kahit naman dati pa, no, ayaw nila magpalabas ng subpoena kasi coercive yun sa isang co-equal nila na
Member of Congress.
Members of Congress, yeah.
Nakikita natin sa video itong si prosecution spokesperson Miro Kimbo nakikipag-usap nga dito kay Representative Toby Tiangco na inaasahang tetestigo na nga ngayong araw na ito.
Si Congressman Tiangco talagang nandun na sa metabi ng witness stand.
Mukhang excited ata siya, yung maali-aligid na eh.
Andiyan sa session hall.
Pero kanina, no, yung sinasabi naman itong si Representative Neptali Gonzales, ng House Majority Floor Leader. Okay, si Toby Tiangco and si Mandanas and then si Remulla, okay, kung halimbawa mag-testify sila, tatlo rin. Sinasabi ng ating guest ngayong araw na to na parang, ang sabi nga nitong ni Representative Gonzales at Tiangco would have to come up with at least 95 who will say na hindi verified yung complaint, hindi yan nabasa, para mabaliwala yung 188. Because yung 1/3, alam naman natin under the Constitution, talaga namang, bruta yan para
sobra-sobra pa.
Oo, makapag-akyat ng impeachment complaint laban sa impeachable officers under the Constitution.
Joseph, kamusta na ito mga senador ngayon? Ano yung mga tinatalakay nila?
Ba't hindi lahat na sa caucus?
Minsan talaga kasi ganyan. Kung halimbawa, itong Senator Miriam Defensor Santiago has made already her point, no? Ang sabi niya kanina, if I can go back to my notes lamang, ang sinabi nitong si Senator Santiago,
no constitutional issue.
Oo, parang yung preliminary hearing may be had and in fact it is the discretion of the court. So parang kung gusto ng preliminary hearing, ay pwede namang gawin ng Senado yan. She has made her point, so I don't think she saw it na there's a need pa for her to go inside and then discuss amongst the other senators. At yun.
Ayan, Senator Villar, Senator Pangilinan. Tapos na ba itong caucus or ongoing pa rin ba?
Malamang ongoing pa. It's done
caucus
when...
Caucus ba tawag o consultation lang?
Ano
ba?
Caucus, I think, yung sinabi niya.
Caucus, okay.
It's done when the Senate presiding officer is out of the chambers and then is...
Okay.
Ito si Vitaliano Aguirre na hear no evil. Hindi mo na nakikita dyan, hindi mo na natatanaw dyan.
Hinahanap nga namin, but then we remembered, di ba, nung as early as, kailan ba yun? Kailan ba siya nag-gano ng...
2 weeks ago.
Oo, 2 weeks ago. Sabi nila is that aside from yung contempt, ay banned ka na dito sa session hall as until dinidinig yung impeachment trial.
Oo.
Pero hindi ba binago yun? Pinagsabihan na lang na mas maingat ka sa susunod.
Hindi na siya ikinulong, pero yung ban sa kanya will stay. Kasi yun yung naunang sinabi ng Senate na parang, okay, di-decide namin at that time kung anong magiging parusa sa'yo, pero for the meantime, hindi ka na pwedeng pumasok sa loob.
Wala bang dyan na medyo nag-tame si Senator Miriam kahit kontra siya kay Justice Cuevas?
Mas huminahon na si Senator Miriam ngayon. Medyo okay ata ang blood pressure.
Okay naman siya at siya ang nag-lead ng opening prayer natin.
Okay. Bas-bas.
Wow.
Okay. Maraming salamat, Joseph Morong. Balikan ka namin dyan mamaya. At siyempre, dito pa rin tayo sa talakayan. Kasama pa rin Professor Rowena Daroy Morales. At ano pa yung obserbasyon natin dito? Dahil yun nga, yung nagpakita na naman ng mga naunang desisyon, itong si Senadora Miriam Santiago, parang nakikita niya walang basehan yung argumento nitong si Justice Cuevas dahil doon sa mga espesipiko na mga desisyon ng ating mga korte, di ba, Professor, parang hindi sakop talaga itong impeachment court natin.
ang nagbasa siya kanina,
Oo.
no? At,
Mga rulings po yun, ano?
po?
Tsaka, mga rulings yun at batas.
Rules of court ang
Rules
binasa
of
niya,
court.
no?
Oo,
Article
oo.
6 as specifically ng rules of court. Pero precisely, rules of court,
Ng court.
judicial court.
Okay.
At matagal na nating paulit-ulit sa sinasabi, nire-remind tayo, may sariling rules ang
impeachment
impeachment
court.
court. At ang gusto lang sabihin kanina ni Senator Miriam is at the discretion of the impeachment court, and the impeachment court has already exercised its discretion.
All right,
Okay.
Professor. Balikan po natin ang impeachment proceedings. Panuorin po natin ito.
The senator from Iloilo is recognized.
Try and very humbly explain. Hello? For the second time, I would like to try and very humbly explain why the ruling of the court, as articulated by our presiding officer, is on all fours with our rules of court. Rule 16 governs motion to dismiss and deals with the separate grounds for filing a motion to dismiss. Here, the pertinent grounds are related to each other. You could file a motion to dismiss on the ground that the court has no jurisdiction over the person of the defending party, or that the court has no jurisdiction over the subject matter of the claim. With respect to jurisdiction over the person of the defending party, the Supreme Court has taught us it is a settled rule that the party cannot invoke the jurisdiction of a court to secure affirmative relief against his opponent, and after failing to obtain such relief, repudiate or question that same jurisdiction. So, what we are being taught is that if you've already accepted jurisdiction of the court and you've even filed affirmative defenses for the consideration of that court, but your affirmative defense is denied, after doing that, you cannot turn around and then repudiate the same question of jurisdiction. Your hands are already tied. And then the other ground is that the court has no jurisdiction over the subject matter of the claim. Once more, to jurisprudence, we can turn and find the following lesson. While jurisdiction may be assailed at any stage, a party's active participation in the proceedings before a court without jurisdiction will stop, ESTOP, will stop such party from assailing such lack of it. Again, the point is the same. You've already accepted jurisdiction, you've tried to obtain relief, and if you don't obtain it, you cannot now turn around and say, but after all, you have no jurisdiction over me. So I'm afraid that the ruling of the impeachment court that no preliminary hearing will be conducted on a special affirmative defense is on all fours with the rulings of our Supreme Court and the rulings as articulated by our president, our presiding officer, have always been totally congruent with the rulings of the Supreme Court.
Thank
Mr.
you.
President, Senator, may we recognize Senator Escudero, Mr. President, before you?
The gentleman from Sorsogon.
Thank you, Mr. President. With the permission of the presiding officer, may I address some questions to the lead defense counsel, Attorney Cuevas? Sir, if I may ask, it is clear that the impeachment court already made a ruling with respect to the motion for preliminary hearing and even on the affirmative defenses itself with respect to the jurisdiction of the Senate and the procedure adopted by the House. The basic concern, Attorney Cuevas, is you might call all 188 signatories and you might end up being bogged down on this issue that has already been decided upon and ruled by the Senate. That's a basic and valid concern by the impeachment court, sir. And secondly, if it was for the purpose of establishing the absence or presence of probable cause, as mentioned by Senator Santiago and ruled by the court in its written ruling, that has already been disposed of by the impeachment court. However, if the purpose is perhaps to set the tone or to, by way of preliminary, to lay the predicate for your general theory of the case, and you will not present 188 and perhaps one or two witnesses on this matter, perhaps some understanding or bending over backwards may be given. But the concern, again, Attorney Cuevas, is baka yung buong 188 ho ay patawag ho ninyo. Ano ho ang balak ninyo?
That is far from my mind, Your Honor, because our attack is not on the number first. Now, secondly, I hope you pardon me for disagreeing with your dissertation that there was already a ruling on this particular case. May I cite the January 12, 2012 dispositive portion? In view of all the foregoing, the motion for preliminary hearing filed by Chief Justice Renato Corona is denied for want of merit. So what was denied in our understanding, and it is clear to us, is only the right to a preliminary hearing, not the affirmative defenses, if Your Honor, please.
The court will decide on that, Attorney Cuevas. But may I get...
No, I'm just saying we have every reason to rely on this. If there was a categorical pronouncement, then probably we could have taken other remedies, if Your Honor, please.
But may we know, Attorney Cuevas, on this issue and on this matter, in the absence of a pre-trial wherein we would have obtained the list of witnesses, insofar as this issue is concerned, who and how many witnesses do you intend to present, if you may know?
Well, we have stated earlier that we are presenting about 20 witnesses, Your Honor, all the entire impeachment proceedings.
On this topic, sir, Your Honor.
Now, on this topic, probably 3 up to 5. Because, for instance, in 3/4, 2/3, let's say there are this number, and 2 or 3 of them were intimidated or coerced to sign one way or the other. So the number representing at least 1/3 is already obliterated. So to us, that will be a facade of false information.
Mr. President,
because you
Your
have
Honor,
a definite number in order to determine what is 1/3. Now, supposing of that 1/3, 1 or 2 were merely coerced, they were compelled to affix their signature without being voluntary on their part. Will that not at least change the color of their signature attached to the affixed to the complaint? That is because we have every reason to rely on the jurisprudence on the point. Since there is no definite article, much less any section of the impeachment rules by this honorable court, then we have to resort, or we have to go to other sources, Your Honor. And we are not totally left without any support whatsoever. What we read into the records are questions where the impeachment complaint was filed by at least 1/3. And to us, it is clear that the mere fact that the complaint is verified complaint was filed by at least 1/3 does not exempt the petitioner or the complainant from observing the requirements prescribed by law in order to comply with the requirements of due process. That is our point. Because left with no alternative, where do we go? There is no appeal. But there is a violation of the constitutional right of the accused. That is therefore a ground for the Supreme Court to take cognizance of the case. If that is a ground, then how else could we assert it? Except by pleadings. And if we do not agree with the decision of we do not agree with the decision of the Honorable Impeachment Court, then maybe other remedies are available to us.
Mr. President, for the record, I agree with the impeachment court with respect to the non-issuance of subpoena to members of the House. However, nothing bars a member of the House from testifying voluntarily if they are called by the defense as their witness.
No.
And insofar as allowing the defense to present evidence on this matter, for as long as it is on a short leash and will not entail the calling of all 188 of them, which would be unreasonable to say the least. And I think counsel will agree with me.
Yeah, we have agreed. I'm sorry.
For the record, Mr. President, Your Honor, that is the position of this representation. So the defense can be given some leeway with respect to developing their case.
I'm not yet crying for liberality in favor of the impeached public official. Many a times, the prosecution had been crying for the extension of liberality on their part. If there is anybody who should cry or call for liberality, it should be the impeached public official, being the accused in a criminal case. Never is there a time where the prosecution asked for liberality. I was a fiscal for more than 20 years. I never asked for any liberality.
We submit and we thank the distinguished counsel for the defense for his
Thank you. Now,
patience,
may
Mr.
we
President,
pose
Your
question, if Your Honor, please. We have 3 members of the House of Representatives whom we intend to utilize as adverse witnesses, Your Honor. If we call for a subpoena, if we ask for a subpoena to compel their appearance, Your Honor, it may again fall under the previous ruling of this Honorable Court. But this time, we are not calling them as ordinary witnesses, Your Honor. They are calling them as adverse party, and the law allows us under the rules of court, Your Honor.
Who are the adverse party that you want to...
For instance, Congressman Abaya, Your Honor, Congressman Kimpo, and Congressman Tanyada, Your Honor. And then we will dispense with Congressman Gonzales. We are calling them not in their capacity as Congressman, Your Honor, but in their capacity as complainants, Your Honor. So they are adverse party, Your Honor. If the court will not lend its assistance to us, we'll have no alternative. We cannot compel them to come here.
All right.
Mr. President, may we recognize the Minority Leader, Senator Cayetano, and then Senator Drilon.
The Minority Floor Leader.
Magandang hapon, Mr. President. Justice Cuevas, magandang hapon po.
Magandang hapon din po.
Gusto ko lang po maintindihan ng mabuti yung posisyon nyo at yung pinag-uusapan natin. Naririnig ko po yung terms na due process and in very layman's term, yung makinig muna bago humusga. Hindi po ba? Tapos yung probable cause, no? Determination of probable cause. Basically, tama ho ba, ang hinihingi nyo sa amin, magkaroon ng preliminary hearing para i-determine precisely kung nagkaroon ang House ng determination ng probable cause o hindi.
Wala na po, because that was denied already.
Okay. So
when we moved or requested for a preliminary hearing, there was already this resolution of January 18.
Sige po. So now you're asking us
to allow. I'm sorry.
Go ahead, sir. Doon naman papunta yung question, please.
We were praying for the liberality of this court and its magnanimity to allow us to present evidence, even on a trial on the merits, to prove our point, Your Honor, which we were not able to do because our motion for a preliminary hearing was denied, Your Honor.
And sir, what you want to prove is that walang determination ang House ng probable cause, ergo, it's a violation of the due process of your client, the impeached official, the Honorable Chief Justice of the Supreme Court. In a nutshell, ho. Go ahead po.
Not only that it is a violation of the due process right of the accused, Your Honor, but it is a constitutional mandate on the part of our judicial department that the accused should be entitled to due process. Notify him, allow him to be heard, and then decide the case.
Okay. Sir, the reason I ask this question is because I am sympathetic in general.
Thank you.
And I always use the example that we use in law school na ang Diyos nga mismo nakita niya na kinain ni Eva at Adan yung mansanas pero hindi niya kagad hinusgahan, tinanong niya, di ba, ba't kayo nagtatago, anong ginawa niyo? So before he condemned, he asked them a question. Having said that, Your Honor, if we look at Article 11, Accountability of Public Officials, Section 3, Paragraph 4, no? In the case of verified complaint or resolution of impeachment is filed by at least 1/3 of all of the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. So my problem, Your Honor, in being sympathetic with your plight is this. If we granted you a preliminary hearing, or if we allow you to present evidence now, saan to pupunta? Pag nagruling po kami na walang probable cause or walang determination of probable cause or hindi kayo dininig ng lower house or ng House of Representatives, sorry to use lower house, the House of Representatives, we will be in effect amending the Constitution. We will be now saying that mali ang paragraph 4 ng Section 3 ng Article 11 because we will be basically telling the House kailangan nyo mag-hearing muna. But, may I finish, Your Honor?
Go ahead, I'm sorry.
But it is very clear here that when you have 1/3 of all members signing the verified complaint or resolution, it shall automatically constitute an article of impeachment. So unlike a case in the fiscal's office, na kailangan ng piskalya i-inform pareho, makinig sa parehong side, and then determine whether or not meron probable cause. In the case of paragraph 4, pag binasa ng congressman at pinirmahan at umabot sila ng 1/3, yun na po ang determination ng probable cause. The Constitution itself does not call for, I'll let you give your side, Your Honor, after this. No? But just to elaborate and please tell me if mali ang pagkaintindi ko or kung you have a different theory about, specifically I'm talking about section, paragraph 4, no? Dahil ako'y naniniwala this is the mode na inakyat sa atin ng impeachment, no? So Your Honor, pag binasa ng congressman to, pag umabot ng 1/3, diretso na to sa Senado. Pag hindi to umabot ng 1/3, nagkakaroon ng proseso sa lower house under paragraphs 1, 2, and 3. During the impeachment of President Gloria Macapagal Arroyo, Congressman T.G. Gingona here, myself, Congressman Joel Villanueva, then Congressman now Senator Chis Escudero. Ito po tanong namin kay sa mga kadebate namin on the opposite side. Sabi namin sa kanila, do you mean kahit na napakalakas ng final namin resolution, kahit klarong-klarong may probable cause, pagka hindi kami naka 1/3, ibig sabihin, ang finding nyo walang probable cause. On the other hand, even if it's a scrap, it's a piece of paper na walang laman, if 1/3 signs, it will go to the Senate at meron ng probable cause yun. And there was always unanimity there, na pagka yung 1/3 nakapirma, pumunta na sa amin yon, ang trabaho namin, hindi i-determine yung probable cause. Ang i-determine namin, number 1, meron bang impeachable ground? May ground ba for impeachment under the Constitution? Then number 2, proceed with trial, whether or not nga guilty yung tao. So, yun po ang problema ko. Assuming I say, I asked for a reconsideration because I voted with the majority and I think the ruling of the presiding officer and of the impeachment court is correct. But assuming for the sake of argument, sabihin natin dapat bigyan ng hearing, dapat payagan ang defense na magpakita ng ebidensya na hindi nagkaroon ng due process or ng probable cause, no? Pero ang Constitution na po nagsabi na kapag yung 1/3 may nakapirma, due process na yon. Dito na siya magpaliwanag. Ika nga ng mga pulis, boss, sa presinto ka na magpaliwanag. Dito po ang sinabi, boss, sa impeachment trial ka na magpaliwanag, wag na sa Committee on Justice. So, Your Honor, my question is, and answer the way you would like to, sir, is, are you saying that unconstitutional ang paragraph 4 or this paragraph is in fact violative of other parts of the Constitution? Kasi if we return this to the lower house, yung effect po will nullifying this mode of elevating an impeachment case to the impeachment court.
Now,
I'm through, Your
Honor.
Honor. Yes.
Thank you, Mr. Senator. It is not merely Justice Cuevas espousing that view. It is the Honorable Supreme Court already. In the 2 cases I have mentioned, the impeachment complaint was filed by at least 2/3, 1/3. And the Supreme Court said that is no exemption
So
from
Your Honor,
the determination of probable
my question
cause.
is, can the Supreme Court amend the Constitution?
Well, it's not amending. That is the interpretation.
But how
There is
can you interpret it any other way? Ang nakalagay po dito, in case a verified complaint or resolution of impeachment is filed by at least 1/3 of all members, the same shall constitute the article of impeachment.
Correct.
Hindi po nakalagay dito, the House shall now have a hearing and determine
Wala
probable
rin naman
cause.
nakalagay dyan that there is no necessity of determining probable
Nakalagay
cause.
po, Your Honor, and trial by the Senate shall forthwith proceed.
Yes, but in this jurisprudence it is stated it can be asserted before the lower house.
Well,
Before the
go
house.
ahead, Your Honor.
If it is denied, then you can go to even if the impeachment case already filed. And if it's the impeachment court may act on it, either granting or denying. So it is a reconciliation.
Your Honor, I will not answer that statement about the Supreme Court because I think in our ruling we mentioned about the ruling of Chief Justice Davide in the Estrada trial. But I'll stop there. I thank you for answering those questions. But I just like to put that on record that I support the decision of the court, and I don't think there's any other logical interpretation of paragraph 4, which I read. No, I mean, if we're going to interpret it that we require the House to have a hearing, it will be the same as the other paragraphs, Your Honor. But anyway, I will let because of due process, and we hear both sides. We hear you're not arguing with me, I'm not arguing with you, but I just want to put that on record, Your Honor.
With due respect, Mr. Senator,
Yes.
if we follow that dictum, then there never can a time be when impeachable officers may be immune from impeachment proceedings filed by any disgruntled individual. Because all they have to do is gather at least 1/3. And there is no more investigation. There is no more probable cause.
But, Your Honor,
it goes direct to the Senate.
that's precise.
If we follow that dictum that will lead to disastrous consequences.
But, Your Honor, if you...
The security of tenure provision will definitely be laid to rest, and it may not be invoked by any impeachable
But
public
just for the
official.
information of the court, Your Honor, that is precisely in the records of the debate of the Constitutional Commission. Yung po precisely ang debate nila. Na if you ask for a majority of Congress to impeach a public official, it will be very difficult to impeach a public official. Pag isa, 5, 10 naman, it will be very easy. So ano yung compromise? When 1/3 affix their signature in a verified complaint or resolution, automatic na, punta na po to sa impeachment court. At tinanong nga doon, but will that be subject to abuse, etc.? Ang sabi nila, it's not that easy to get 1/3. And we cannot assume that the House of Representatives will not act in good faith. So, Your Honor, that's the balancing of accountability and transparency here. If you make it almost impossible, then you give the Supreme Court justices immunity. Ang presidente po, 6 na taon lang siyang immune sa suit. Ang Supreme Court Justice, pag 55 years old ka na-appoint, ang sabi po nila sa mga Supreme Court cases, in fairness to them, not only now, matagal na itong mga kaso na to, hindi ka pwede mag-file ng disbarment, hindi ka pwede mag-file ng criminal case. Kailangan impeachment muna bago mo silang kasuhan. Dahil kung hindi, indirectly tinatanggal mo sila. So kung pahihirapan naman natin ng husto kung paano sila i-impeach, maghihintay tayo hanggang 70 years old na sila, hanggang mag-retire at dun mo lang pwedeng kasuhan. Wala nang remedyo po ang taong bayan. Ang mamaya, wala nang pupuntahan.
Hindi po.
No, Your Honor, I was just responding to your thesis that it will be so easy. But I mean, I've been a congressman for 3 terms and I've been monitoring Congress. I think ilan pa lang po ang na-impeach by this mode.
I think we have...
But thank you, Mr. President. Thank you for this time.
Mr. President. The Senator Drilon.
I think we have sufficiently argued this case. But anyway, the gentleman from Iloilo is recognized.
Mr. President, I'll be very brief. The defense here, Mr. President, is making a plea that they be allowed to present evidence on their affirmative defenses because allegedly the January 18, 2012 ruling did not rule upon the affirmative defenses, but only the motion for a preliminary hearing. Mr. President, the grounds relied upon by the affirmative defenses is precisely the ground relied upon when the defense asked for a preliminary hearing. And in fact, on page 2 of the resolution of January 18, it says, the Chief Justice claims that since the verified complaint for impeachment lacks a proper verification, it should be treated as an unsigned pleading which produces no legal effect and should therefore be dismissed. The January 18, 2012 ruling of this court, Mr. Senate President, categorically validated the verification. It ruled, quote, it appearing that the filing of the verified impeachment complaint was made in accordance with paragraph 4, section 3, article 11 of the Constitution, there is no more need for a preliminary hearing to receive evidence on this matter, close quote. If there was no need to present evidence on the matter of the preliminary hearing, there is no need to present evidence on the affirmative defenses. So it is not true that it was only the motion for a preliminary hearing that was denied. It is the validity of the verification itself that was ruled upon. And the purpose, obviously, of a hearing on the affirmative defenses is to have the case dismissed because of lack of proper verification, which has already been ruled upon by this court on January 18, 2012. Thank you, Mr. President.
If that commentary, Your Honor, was made by the members of the prosecution arm, we would have no objection, Your Honor.
This is the rule.
We are worried, Your Honor, that this may be interpreted, Your Honor, as an argument by a prosecutor.
I take exception
case,
to the statement of the prosecution of the defense counsel, and that is totally improper. We are just reading. I am still speaking.
Go ahead.
Do not interrupt, because I was just explaining the ruling of the court.
May I request the majority floor leader to reread the ruling of this court on what date was it?
Resolution of January 18, 2012, Mr. President.
Yeah, read it.
The Chief Justice claims that since the verified complaint for impeachment lacks proper or a proper verification, it should be treated as an unsigned pleading which produces no legal effect and should therefore be dismissed. I will just read the pertinent portions. Mr. President, to continue in the resolution. During the impeachment proceedings of President Joseph Ejercito Estrada before the Senate, case number 001-2000, a motion to quash was filed by him, alleging, among others, that the verification in the impeachment contract was not the verification prescribed by the Constitution. The impeachment complaint, the contract was probably a typographical error. The impeachment court at that time found the verification to be sufficient and ruled that the perceived flaw in it was inconsequential and not fatal. Speaking through Chief Justice Hilario G. Davide Jr., who was the presiding officer of that time, the impeachment court stated in a resolution dated 29 November 2000 that verification, like in most cases, required by the rules of procedure, is a formal and not a jurisdictional requirement. It is mainly intended to secure an assurance that matters which are alleged are done in good faith or are true and correct and not of mere speculation. By Miriam Defensor Santiago. There appears to be no cogent reason to depart from this ruling. On its face, there appears to be no patent or obvious defect in the verification contained in the verified impeachment complaint. The wording or content of the same is substantially in compliance with the third paragraph of Section 13 of the Rules of Procedure in Impeachment Proceedings of the House of Representatives. It is not necessary for the verification to be couched in the language of the rules of court, inasmuch as this particularly wording is not strictly required by the Constitution. If this had been what was required, the Constitution would have specified the exact required wording of the verification. A verification is an oath or affirmation. Under the Constitution, there is only one instance wherein the exact form of an oath or affirmation is specified, and this is found in Section 5, Article 7, when the President, Vice President, or the acting President takes his oath or affirmation before entering on the execution of their office. Since there is no precise wording required for the verification of a complaint in case of impeachment under Paragraph 4, Section 3, Article 11 of the Constitution, the actual verification in the complaint as per the rules of impeachment of the House of Representatives is sufficient and adequate for the purpose. In view of all the foregoing, the motion for preliminary hearing filed by Chief Justice Renato C. Corona is denied for want of merit. January 18, 2012, Mr. President.
All right. We have discussed this lengthily.
May we recognize Senator Arroyo, Mr. President, before
the gentleman from Makati and Bicol.
Thank you, Mr. President. May I ask the defense, just what is the objective of the defense in filing this motion? What is your goal? Because as I see it, supposing the Senate will grant your request, have a hearing, and then it turns out that your allegations about the defects, etc., are true, would you say that the Senate has to dismiss the complaint?
To us, it will appear...
Yes, I'm asking.
To us, Your Honor, it will appear that there is no valid complaint because the complaint was not in accordance with what the Constitution requires, which is the right of an impeached public official to due process. And the requirement of due process states notice and hearing.
Ergo, what you mean is that if you successfully prove your allegations, the Senate must perforce dismiss the complaint.
I do not think there is nothing illegal in that.
Well, that is precisely the problem. After 7 weeks and 27 days, we are now going to decide it on a practically the arguments that you have stated. But I was in the prosecution in the case of President Estrada. The same issue arose, the defects and all. Our argument is that the House impeaches, the Senate hears and decides. What the House transmits to the Senate, faults and all, everything, defects and all, will have to be accepted by the Senate because the Senate cannot direct the House on how to make an impeachment complaint because the Constitution simply says that the House impeaches, the Senate tries and decides. So, if I am thinking about the ultimate end of this goal, you're asking us to, in effect, pass judgment on what the House did. This defense is asking the Senate to decide and say the House is wrong. The House did this and did that. Now, can we do it as a Senate? But the House prepares the complaint. And just like in the Estrada trial, defects and all, it was accepted. That is the precedent. It was accepted. That was the argument. So, in fact, let me ask for just a little while. No, prosecution. Do you have any objection to the statement of that Congressman will be presented here? This is not my question. This is what Senator Escudero, who already spoke before me, asked me to ask.
We would object, Your Honor, because the House has already performed its constitutional mandate of filing, as brought out by the good Senator. The House has the exclusive power to initiate all cases of impeachment. And the House, through that mode of direct filing under subparagraph 4 of Section 3 of Article 11, indeed filed by the vote of almost 2/3, not only 1/3. And the power of impeachment is an emergency power. Where can you find an act of a legislative body that the vote required is the minority, 1/3? Because you want to make an officer accountable. So that portion...
I think that's been sufficiently explained. So, that's... Justice Cuevas, my friend, I mean, that is the only question we have now. You're asking the Senate to nullify, in effect, what the House did. It's just...
If we did that, Your Honor, we have predicated our action on the decision of the Supreme Court, Your Honor, that we can raise violation of the impeached public official to due process before the House. And if it is not acted with favor, we can bring it even before the Senate. Well, that is the ruling of the Supreme Court.
Yes, but in the Davide case, The Davide case never reached the Senate.
No, that is not the Davide case, Your Honor. I'm sorry.
I'm sorry. Whatever you are referring to.
It's the Francisco case.
Oh, Francisco case. Now, it reached only, it did not get out of the House. So the ruling was still, the Supreme Court made a ruling over a decision or action made by the House. But in this case, the Senate has already acquired jurisdiction.
Precisely, that was the basis of the ruling in that case, that if it is not honored by the House of Representatives, then you can bring it up before the impeachment court, which is the Senate. That's not my pronouncement.
Which is also my question.
That is the pronouncement of the court. And it remains valid, Your Honor, unless modified, reversed, or revoked by the Honorable Supreme Court.
At any rate,
may I, Mr. President? You had Christmas season. You could have brought that to the Supreme Court, just the same as in the Francisco case, before it reached the Supreme Court, or before the Senate, before the Senate acted on it. You know, but the Senate has already acquired jurisdiction. You want
there is no possible time, if Your Honor please, to bring it. It was a blitzkrieg action. If you have gone over our complaint, we delineated very particularly and specifically why we were not able to act one way or the other. It's like being hit by thunder, Your Honor. Wala na.
Thank you very much, sir. Thank you.
At any rate, the chair would like to end this matter and decide it so that we can proceed.
Mr. President.
Yes.
Senator Pimentel and Senator Pangilinan. Senator Pimentel wishes to have the floor. Just
the gentleman from Misamis Oriental.
I will just solicit a fact, Mr. President, which might help you decide the issue, the pending issue. Mr. Counsel, did not Chief Justice Corona file a petition with the Supreme Court? And that petition also questioned or raised the issue of denial of due process?
That's correct, Your Honor.
So you are pursuing that issue before the Supreme Court, and at the same time pursue it before this impeachment court?
That's correct, Your Honor.
Okay.
They are predicated, however, on different factual menu, Your Honor.
Anyway, that's just a factual, a question of fact, so that the presiding officer will be guided. But just to make it of record, although it has been, it is basic doctrine that it is the Supreme Court which interprets the Constitution, in my opinion, the House and the Senate are not prohibited from interpreting the same Constitution, and especially Article 11 on impeachment, because if you read the sections on impeachment, these are actually directed to the House and to the Senate. Hence, in my humble opinion, the Senate can interpret Article 11 on impeachment, and we will rule on the pending issue given or asserting the Senate's power to interpret the Constitution. Just as the Supreme Court can interpret the Constitution, the Senate, as the impeachment court under Article 11, also has the same right to interpret the same sections in the Constitution.
As of date, I do not find any valid objection to such an interpretation that may be made by this Honorable Impeachment Court, Your Honor.
Anyway, thank you for that additional factual input, Mr. Justice.
Thank you also.
The gentleman from Pampanga, are you raising your hand? You have 2 minutes.
Yes, thank you, Mr. President. Just very quickly, Mr. President, all throughout the 27 days of the trial, we have been focused on the articles of impeachment. Article 1, Article 2, Article 7, and Article 3. And then we have abandoned, or the prosecution has abandoned the other articles of impeachment. With these affirmative defenses being raised, may we know under which article will the evidence presented, to be presented or being asked to be presented, under which article would it fall? Because I ask this, Mr. President, because we have, on many occasions, prevented the prosecution from presenting evidence precisely because it is not within the ambit or does not fall within any of the articles of impeachment. Therefore, it is immaterial, irrelevant.
That is...
So may we know under which article will these affirmative defenses be, will it fall under?
That's directed against me, Mr. Senator.
Yes,
thank you.
Justice. Thank
now, it will cover the entirety of the impeachment complaint, Your Honor.
All right. All right. Now the chair will make a ruling. Under the Constitution, the sole power to try and decide all impeachment cases belong to this court. Only this court has the jurisdiction. The Supreme Court has no jurisdiction to try and decide impeachment cases. That's one. Once the articles of impeachment reaches this House, the command of the Constitution is that trial shall forthwith proceed. Due process is not only the sole function of the House of Representatives. Due process is a function of this House that tries and decides all impeachment cases. The facts in this case are that an impeachment articles of impeachment was referred to this Senate by the House. 188 members of the House filed that articles of impeachment to this House. And the named complainants in that impeachment case are Representatives Neil C. Tupas Jr., Joseph Emilio A. Abaya, Lorenzo R. Tañada III, Reynaldo V. Umali, and Arlene J. Bagao. When this Senate, sitting as an impeachment court, received the articles of impeachment, it issued the proper processes to notify and inform the respondent of the existence of these articles of impeachment against him, and requested or ordered the respondent to file his answer within 10 days, which the respondent Chief Justice did. And a reply was equally filed by the prosecution with respect to the answer filed by the respondent Chief Justice, so that at least this court has followed the principle of due process that is demanded in a case like this. And so therefore, having made the ruling that this court assumed jurisdiction under the full faith and credit given to the processes of the House of Representatives, and knowing that it has jurisdiction, it proceeded with the trial, and so therefore, as much as we want to accommodate the desire of the defense, this presiding officer, with the permission of the impeachment court, regrets to deny the desire of the defense. So you proceed to present your evidence.
May we know if the defense is ready, Mr. President?
We are ready, Your Honor.
All right, proceed to present your evidence.
May we call on Congressman Tobias, Your Honor. Tobias Chanco, Your Honor.
What is the purpose of this witness?
Well, We ask permission, Your Honor, that Attorney Dennis Manalo be allowed to handle the taking of the testimony of this witness, Your Honor, and he will state for the record the purpose for which Congressman Tobias will be presented as a witness.
Yes.
Thank you, Your Honor.
Counsel for the defense may proceed.
Good
Please
afternoon.
state the purpose of this witness.
Good afternoon, Your Honor.
Yes.
We are presenting, Your Honor, Congressman Tobias Chanco to prove or lay the basis or introduce the factual background, Your Honor, of the material defenses in CJ Corona's answer for all the articles of impeachment. Particularly, Your Honor, we are referring to paragraph 2, paragraph 3, 4, 5, 9, 10, 11, 12, 13, 14, 15, Your Honor, of the prefatory statement, Your Honor, in the answer. With the permission
Of
of
the
Honor-
articles of impeachment.
Yes, Your Honor, for all the articles of impeachment, Your Honor.
Are you going to present him to establish the fact that there's no verification?
Your Honor, in view of the ruling of the Honorable Court, we have decided, Your Honor, to forego that purpose
All right.
because it will not serve any useful purpose in the proceedings anymore.
All right, proceed.
Thank you, Your Honor.
Put him under oath.
Please raise your right hand. Do you swear to tell the truth and nothing but the truth in these impeachment proceedings?
Yes, Your Honor.
So help you God.
Thank you.
Counsel, proceed.
Mr. President, just a parliamentary inquiry. Did we hear the counsel state that this witness is being presented for the articles of impeachment, Article 1?
All the articles of impeachment.
All
Your
the
Honor.
articles of impeachment. Mr. President, we have discussed this in caucus earlier, and the issue of whether or not evidence can be presented on the other articles other than 2, 3, and 7.
We have already made a ruling to that effect. In fact, I read the ruling orally into the record that this court will not allow any reception of evidence on Articles 1, 4, 5, 6, and 8. Neither the prosecution nor the defense will be allowed to present any evidence for or against these 5 articles because it has been withdrawn by the prosecution and this court will not consider them at all. They will not vote on them, they will not accept any evidence on them, and they will not render any verdict on them. And so, be guided accordingly.
Yes, Your Honor. When we referred to all articles of impeachment, it is understood that we are only referring to the remaining articles of impeachment that have not been withdrawn by the prosecution. Your Honor. Good afternoon, Mr. Witness.
Yes, good afternoon, Your Honor.
Mr. Witness, since when have you been a congressman?
I've been congressman since noontime, June 30, 2010, and this is my first term as congressman of the Lone District of Navotas, Your Honor.
For the record, Mr. Witness, can you just please state your name?
I am Tobias M. Tiangco of 90 M. De Vera Street, Navotas City. Tapos na, nag-out na ako, boss.
Yeah. And Mr. Witness, for the record, what district do you represent?
The Lone District of Navotas City, Your Honor.
This is the fishing capital of the Philippines. Am I correct?
Fish trading capital of the Philippines. It used to be the fishing capital, but it's now the fish trading capital, Your Honor.
And Mr. Witness, what is the estimated population of Navotas?
During the census of 2007, I think it was over 250,000, more or less, Your Honor.
Prior to being a congressman, Mr. Witness, have you occupied any other government position?
Yes, Your Honor.
Ano po yung mga position na ito?
Ako po ay naging acting mayor from June 30, 1998 to February 1, 1999. Ako ay bumalik sa pagka-vice mayor from February 1, 1999 to May 2000, at nung namatay ho yung nakaupong mayor, ako ay nag-assume ng post ng mayor ng May 2000 hanggang 2001. Tapos ako ho ay tumakbo ng mayor ng 2001, 2004, and 2007, Your Honor.
Napakahaba po ng inyong pinagsilbihan sa inyong bayan ng Navotas. Tingin ko'y mahal na mahal ho kayo ng mga Naboteños.
Yes, Your Honor. Diyan na ho ng team ko.
There's no question there. No. May we ask that be stricken from the record?
No. Wait a minute. Counsel, proceed. You're on direct examination.
Yes, Your Honor. Mr. Witness, you mentioned that you are a congressman, a first-term congressman. Are you familiar with the duties of a congressman?
Yes, based on the rules of the 15th Congress, I am familiar with our duties and responsibilities, Your Honor.
And what are your duties as a congressman?
Mainly, it's legislative work. It's attending, if you will define legislative work, most of the legislative work is attending committee hearings and, of course, in the afternoon, attending plenary sessions, Your Honor.
Aside from these activities, are there other activities that you participate in as a congressman?
Formally, none, Your Honor, but there are other informal functions and other informal meetings, Your Honor.
What are these informal meetings? What are they called?
Social gatherings, caucuses.
Ano po ba itong caucus? Yung sinasabi niyong caucus, ano po yun?
Doon ho sa House, ang caucus ho is a private meeting of a group of people depending on what type of caucus. No? Depending kung anong caucus ang sinabi. Pag sinabi hong all-member caucus, ibig sabihin ho, caucus ng lahat ng miyembro ng House. Pag sinabi hong all-majority caucus, yan ho ay caucus ng lahat ng miyembro ng majority. Pag sinabing minority caucus, yan ho ay pagpupulong ng mga miyembro ng minority. Pag sinabing party caucus, yan ho ay caucus ng isang partido. So depende ho kung anong klaseng caucus po, Your Honor.
Ano po ba ang ibig niyong sabihin sa majority sa Kongreso o mayorya?
Base ho sa aming rules, yung hong mga miyembro na boboto sa nanalong speaker, yun ho ang mga miyembro ng tinatawag na majority. Yun naman hong boboto sa susunod o sa number 2 ay yun ho ang mga miyembro ng minority.
Nabanggit nyo po na yung pong caucus ay isang private meeting. What do you mean by that? That it's a private meeting?
It's a private meeting in the sense na kung kami ho ay nasa committee, meron hong roll call at may agenda. Kung kami ho ay nasa plenary, meron din ho nagsisimula ang plenary, siyempre sa pagkanta ng national anthem, sa pag-invocation, roll call, tapos order of business. So meron hong agenda. Sa caucus, minsan ho, wala hong formal advice at wala hong agenda na sinasabi. Kung minsan ho, sasabihin sa amin, there is an all-member caucus. Sasabihan o makakatanggap po kami ng text na there is an all-majority caucus. Ganun ho. Pero wala hong definite agenda kadalasan ang caucus.
Sinabi niyo po kanina na bilang congressman, kayo po ay uma-attend din sa mga caucuses, ano? Ano po bang mga caucuses itong naatinan nyo na?
Ang huli ko hong na-attendan caucus ay yung all-majority caucus noong December 12, 2011 ho. Kami ho ay nakatanggap ng text message nung siguro 6:30 to 7 p.m. ng December 11 galing ho kay Attorney April. Siya ho ang sekretarya ni Speaker Belmonte. Ang natanggap ko hong text message is there will be an all-majority caucus at 2:30 p.m. tomorrow at the Andaya Hall. Pero wala hong agenda.
Wala pong agenda.
Opo.
Ito pong pagkatanggap nyo po nung text message na ito, no, na meron kayong all-majority caucus, meron po bang nabanggit kung ano po ang tatalakayin dito?
Already answered, Your Honor.
Wala po.
Already answered, Your Honor.
Yes, Your Honor.
Ano po what was your reaction, Mr. Witness, upon receipt of this notice?
Wait, Your Honor, because he's making me laugh, Your Honor. Ang una ko hong reaction noong natanggap ko ho yung notice na magkakaroon ho ng all-majority caucus ay medyo kinabahan ho ako dahil nung araw na yon may mga ugong-ugong sa text din na magkakaroon ho ng impeachment kay Chief Justice Corona. So, ayoko hong I was hoping against hope na sana hindi yun ang pag-uusapan doon sa all-majority caucus. Sabi ko ho, sana RH bill na. Ngunit parang hindi pa pwedeng RH bill kasi kung RH bill yun, dapat all-member caucus. So parang sabi ko, mukhang ang pag-uusapan dito ay yung impeachment ni Chief Justice Corona.
Mm-hmm. Ano po bang mga preparasyon ang ginawa ninyo bago dumalo sa caucus na ito?
Ang preparasyon na ginawa ko is I tried to psych myself up, no? Pinilit kong pilitin yung sarili ko na kung sakaling impeachment ang pag-uusapan, pikit mata na ho akong boboto ng yes sa impeachment.
Bakit po?
Tatlong bagay ho. Unang-una, masama ang naging experience ko noong hindi ho ako bumoto ng yes sa impeachment ni Merceditas Gutierrez dahil yan ang number one. No? Number two, alam ko ho may numero na eh. So bakit ka pa hindi boboto? At number three, ayoko hong mapag-initan I don't want to catch the ire of the most powerful man in the country who has a very high popularity rating, and that is the President of the Philippines. No? Alam niyo, 9.5 years, kalaban ko si GMA from 2001 and 2010, and the President can make life miserable for you. With the vast powers given under the Constitution, pwede hong maging miserable ang buhay ng isang tao pag kinalaban, pag hindi kagusto ng Pangulo. So for those three reasons, sabi ko, ayoko na ng gulo, I will just psych myself up to vote. No?
You mentioned na nagkaroon po kayo ng masamang experience sa impeachment ni dating Ombudsman Merceditas Gutierrez. Ano po itong masamang experience na sinasabi ninyo?
Ang impeachment ni Merceditas Gutierrez, kung matatandaan ko ho, is March 21, 2000. Your Honor, can I get my notes just to make sure of the date?
Your Honor, the witness is asking permission to refer to his notes so that he could get the date exactly.
The witness is authorized to refer to any material that he has.
Your Honor,
The witness, Your Honor, is going over his notes.
Yes.
Let the record show that.
yes, Your Honor.
Proceed.
Your Honor, March 21 ho, pinagbotohan ho yung impeachment ni Mercedes Gutierrez. Nung Sabado ho, before March 21, so ang ibig sabihin ho nun is March 19, may mga kumalat na text messages allegedly coming from June Abaya, Chairman June Abaya, na sinasabi yung mga boboto ng no sa impeachment ni Mercedes Gutierrez ay 0 as in 0 sa PDAF, no?
Your Honor, we have to object to that because the witness is testifying on a text message.
No, Your Honor, but let me proceed.
The witness may answer.
No, but that is just the introduction, Your Honor.
There is already a ruling, Mr. Witness.
Based on the journal number 65, March 21 of the House of Representatives, Your Honor.
Bago po kayo magpatuloy, let me just propound the questions, Mr. Witness, so that we will have an orderly narration of the events. There are two things that I want you to clarify first. First, you mentioned Mr. June Abaya. Who is Mr. June Abaya?
Chairman ng Committee on Appropriations, June Abaya. So meron hong supposedly text message na nanggaling sa kanya na yung boboto ng no sa Mercedes Gutierrez impeachment ay 0 as in 0 sa PDAF.
Your Honor, that's hearsay, Your Honor.
Ito pong,
we object to the being hearsay.
Let the witness answer.
Ito pong committee on appropriations, saan pong committee ito?
Committee ho ito sa House of Representatives. Okay, kung papayagan niyo ho ako para patunayan ko kung hindi hearsay ito. Base ho sa journal number 65, Monday, March 21 of the House of Representatives, Your Honor, if I may be allowed to read.
Read it. Proceed.
Remarks of Representative Gonzales. Upon recognition by the Chair, Majority Leader Gonzales N. Neptali remarked that when the subject text message circulated in the morning of Saturday, March 19, he got a call from the Speaker, Belmonte, who asked him to verify the same. He stated that in his phone conversation with Representative Abaya, the latter categorically denied having sent the text message. Representative Gonzales further informed the body that in an informal caucus called upon by the Speaker the previous day and attended by the various parties comprising the majority coalition, said text message was denied and they were assured that no member would be punished for her vote in the impeachment. So, unquote. So, ito ho ang nagpapatunay na hindi ho hearsay ito. Na ito ho ay mismong kinonfirm at binanggit ng majority leader. Ang nakakapagtaka ho dito, bakit ho hindi si Chairman Abaya ang tumanggi kung siya ang sinasabing pinanggalingan ng text at si Majority Leader Gonzales ho ang tumanggi doon sa text message, Your Honor.
Mr. Witness, may I see the document that you have just read? The witness is producing, Your Honor,
just a minute. Just to clarify, what is the relation of June Abaya to Joseph Emilio A. Abaya?
I don't know. I call him June Abaya, Your Honor, so I don't know if he is one and the same.
Is this June Abaya that you mentioned in the room, in the impeachment court today? Can you please look around?
Yes, boss.
Yes,
he is here, Your Honor.
The person referred to as Mr. June Abaya, Your Honor, is present in court. May we ask that the person who was pointed to by the witness to please identify himself?
We confirm the identity.
All right. It's already confirmed. Proceed, Counsel.
Yes, Your Honor. Thank you. May we request, Your Honor, the prosecution to confirm that the exhibit...
We admit, Your Honor.
Okay. The exhibit, Your Honor, pre-marked
You do not have to make that as an exhibit. That is public. That can be taken judicial notice of by this court.
Yes, Your Honor.
That's an official record of the other half of the of Congress.
Just for the convenience of the court, Your Honor, knowing that there is already a judicial notice of this, we
You want to mark
pre-mark
it?
Exhibit 64, Your Honor.
All right, mark it according.
Can I have back my copy, Your Honor?
Admitted.
Okay.
Ito.
Please proceed, Your Honor.
Yes. Nabanggit niyo po yung salitang PDAF.
Yes, Your
Ano
Honor.
po ba ang ibig sabihin nitong PDAF?
Ang ibig sabihin ho nun is Priority Development Assistance Fund o yan ho ang tinatawag na budget ng bawat isang congressman o senador para sa proyekto sa kanyang distrito. No?
Bakit po ba importante itong PDAF na ito?
Natural ho, Your Honor, dahil kahit kami legislator, kami ho ay linalapitan ng aming mga constituents for infrastructure projects o mga pagawaing bayan.
Counsel, with the permission of the witness, what is the purpose of this line of question?
The purpose, Your Honor, is to set the background, Your Honor, for the defenses raised in the articles of impeachment, Your Honor.
To impugn the motive of the House?
Precisely, Your Honor. We believe, Your Honor, that there is no basis, Your Honor, in proceeding with the filing of the case, that the motivation, Your Honor, is political. And in fact, Your Honor, this witness is testifying at the moment on the proof of pattern or scheme or the modus operandi, Your Honor, that took place in the House, Your Honor, with regard to measures sponsored by the administration.
Proceed.
May we be heard on that? We may object on that purpose, Mr.
No,
President.
let the witness, the examination proceed.
Sige po, nung nabanggit po on record itong text message po ni Congressman June Abaya, ano po nangyari matapos nun?
Hindi, nagkaroon ho ng botohan. Yun nga ho, ako ho ay bumoto ng no sa Merceditas Gutierrez impeachment complaint, Your Honor.
Bakit po ba? Ano po ba nangyari dun sa inyong PDAF? Ukol dun sa impeachment ni Merceditas Gutierrez?
Tinanggi nga ho na walang ipitan ng PDAF, ngunit yung PDAF ko ho ay sinabmit ko ho ng February 21 at February 22. Nung Mayo ho, yung ibang mga congressman ay rinilisan na ho ng SARO o yung tinatawag nating approval ng pagpagawa ng proyekto. Ako ho, umabot na ho ng Mayo, biglang nakatanggap ho ako, yung staff ko ng tawag magmula sa opisina ni can I look at my records, Your Honor?
Go ahead.
Opo. Yung soft ko ho, worth 15 million o yung social services na tinatawag na ginagastos ho namin sa medical assistance, scholarship, financial assistance to indigents na worth 15 million, tinanggap ho sa office ni Chairman June Abaya ng February 21 at yung hard po, tinanggap po ng February 22. Wala ho ako narinig na sagot. Nagulat na lang ho ako nung yung staff ko ho ay tinawagan after 3 months na by a certain Noel from DBM regarding the soft and a certain OCHI of the Committee on Appropriations regarding the hard. No? If I may be allowed to explain.
Mr. Witness, may I just ask you to pause for a while so that we can have the documents marked. What is this letter that you mentioned you made to Congressman Abaya on February 17 for your soft and hard projects?
It's dated February 17, Your Honor, but it was received formally February 21 and 22. It is the 2011. It is the list of priority projects kasi kailangan ho namin isubmit yung listahan ng priority projects.
Your Honor, we have pre-marked these documents mentioned by the witness as our Exhibit 65 and 66, Your Honor, as with sub-markings, Your Honor. And we would like to ask the prosecution whether they are also admitting the authenticity, Your Honor, of this document.
Prosecution?
Yes, Your Honor. We admit, Your Honor.
All right. Let it be recorded that the prosecution admitted the authenticity of the subject exhibit.
No, meron na. You also mentioned that there was a letter of May 30 to a certain Florencio B. Abad. 2 letters, in fact.
Yes, Your Honor, because as of May 30, I still did not have kahit isang SARO, wala pa ho ako. Kung mababanggit ko ho, ako ho ay nag-submit ng 15 proyektong pang social projects, tsaka 4 na proyekto na pang infrastruktura. Ngunit hanggang Mayo at 30, wala pa rin hong iniwi-release na SARO or approval sa akin. Samantalang, sa iba ho, halos na-release na ho lahat.
This document, letters to Florencio Abad, have been pre-marked as our Exhibit 67 and 68. Will the prosecution admit, Your Honor, the authenticity of these documents as well?
Prosecution?
Yes, we admit, Your Honor.
All right.
Okay, Mr. Witness.
Let the fact of admission be recorded.
Okay. Thank you, Counsel. Mr. Witness, your letters mention that there were corrections required from you. What are these corrections?
Please allow me to explain, no? Ang bawat isang proyekto, isang SARO ho yan. So, kung 15 ang sinabmit ko doon sa soft o sa social projects, dapat 15 SARO. Nung tumawag ho yung si Noel, ang sabi ho, doon sa 15, 3 ho ang hindi in accordance doon sa DBM guidelines. Ngunit yung 12 ay approved in accordance. Ngunit ang nakakapagtaka, yung 15 yon hindi release. Okay?
So because of the three non-conforming projects, all 15 projects were not, all the SAROs for the 15 were not released. Am I understanding you correctly?
As of May 30, dahil isa-isang SARO ho yan, hindi naman sabay-sabay minsan release. Ang nangyayari dyan, pag meron ka hong non-compliant, i-release lang yung compliant. Pero in my case, yung 15 ho, hindi release. Pagdating ho sa hard, ganun din po. Hindi ho release din yung SARO para doon sa mga infrastrukturang proyekto, para doon sa mga kalsada at drainage system sa Nabotas. Dahil lang ho sa isa na worth 334,000 out of 20 million na hindi ho release sa DPWH dahil yung isang yon ay hindi daw sang-ayon sa DBM.
Para po maging klaro, ano po ba itong mga sinasabing hindi sang-ayon sa mga requirements ng DBM?
Okay, doon ho sa hard, ang title ko kasi is Upgrading of Open Space at Block 31 Phase 2 Area 2. Mali daw yun. Ang dapat daw hong title ay Upgrading of Multipurpose Pavement. So magkaiba daw ho yung open space at multipurpose pavement. So pero sa akin ho, wala akong pinagkaiba yung open space tsaka multipurpose pavement. Doon naman ho sa soft, yung financial assistance for scholarship, ang sabi ho sa akin, ibigay ko ho daw yung pangalan ng mga scholar at saka kung saang eskwelahan ho papasok. Eh, paano ko naman ho malalaman kung sino yung scholar tsaka kung saan eskwelahan papasok kung wala pa ho yung pondo? Siyempre, hindi naman ho ako kukuha ng scholar nang wala yung pondo dahil pag hindi ho rinilis yung pondo, paano matutuloy yung scholarship noon? So, I could not accept this.
Mr. Counsel, we will give you all the leeway to ask this question, but what is the materiality of all of this story to the defense of the respondent?
Your Honor.
You're trying to prove that the impeachment case was politically motivated.
Yes, Your Honor, and we're trying...
And please go direct to the point.
Yes, Your Honor.
Not go into the matter of dissecting the process of releases of funds from the DBM to the members of Congress, because we do not have time.
Yes, Your Honor. We will move forward, Your Honor. Ito pong sulat ninyo kay Secretary Abad of the Department of Budget and Management. Ano po ang naging response dito?
Sumulat ho ako ng May 30, hindi ho sumagot. Sumulat ho ako ng June 27, hindi rin ho ako sinagot.
Okay, ito pong June 27 na letter ninyo, nasa inyo po ba yan?
Yes, Your Honor.
We have pre-marked, Your Honor, a letter from the witness addressed to Secretary Abad dated June 27, pre-marked as our Exhibit 69. Will there be an admission?
We admit, Your Honor.
Thank you, Counsel. June 27, 2011. Now, Mr. Witness, ano po ang naging reaction po ni Secretary Abad dito po sa last letter nyo na June 27, 2011?
Wala rin po, hindi rin ho sumagot.
Okay, ano pong ginawa ninyo nung walang sagot?
Nung walang sagot, ako ho ay gumawa ng press release na sinabi ko na dahil sa aking no vote, iniipit ho ni Secretary Abad yung aking PDAF.
Ito po bang sinasabi niyong press release, meron po ba kayong prueba nitong press release na sinasabi ninyo?
Xerox copy lang ho ng mga dyaryo, Your Honor.
Ito po ay inyong kinolekta, mga clippings ng dyaryo ninyo?
Yes, Your Honor.
Nandun po sa inyo ngayon?
Yes, Your Honor.
Your Honor, we have here pre-marked, Your Honor, the news clippings of marked as our Exhibit 70, 71, 72, 73, 74, and 75. Will the prosecution admit that this is the document in the possession of the witness, but not necessarily the publication?
We will admit as to the existence of the publication, but not as to the contents, the truth of the contents.
All right, mark the exhibit and present them for whatever they are worth.
They have been pre-marked, Your Honor.
All right.
Okay.
Read the markings into the record.
Exhibit 70, which is a newspaper clipping from the Abante Tonight, dated July 11, 2011.
Admit? Your Honor, we admit.
We have been directed to read it into the records.
No, just
we admit already.
Just submit them as exhibits.
Thank you, Your Honor. We will continue. Ano po nangyari matapos po nitong press release na sinasabi ninyo?
Nagulat ho ako dahil nag-text ho sa akin si Secretary Butch Abad.
Ano po ang sinasabi niyong text?
Pwede ko bang basahin? Nasa cellphone ko pa ho.
Proceed.
Tsaka may kinunan ko ho din ng litrato eh. It is a text message of Thursday, July 14, 2011 from Secretary Butch Abad. Sabi niya ho, Kong Tiangco, I read your PR today, Rear PDAF. On my own, I cannot withhold any legislator's PDAF. I suggest you find a way to talk to Pinoy. The Speaker can help you along this line.
Counsel for the prosecution. The newspaper clippings that we have marked earlier extends up to Exhibit 77. Will there also be an admission, Your Honor?
We admit.
Okay, thank you. yung pong binasa ninyo, ano po bang ibig sabihin ano pong pagkakaintindi nyo nung salitang PR?
Yan ho ay tawag namin sa press release.
Sinabi nyo rin po na nakunan nyo po ng picture itong telepono ninyo that contains the text message. Pag pinakita ko po sa inyo itong picture na ito, ma-identify nyo po ba ito?
Yes, Your Honor.
I am showing, Your Honor, Exhibit 78, a copy of the picture taken of the cell phone of the witness, Your Honor. We request that he confirm that that is the picture which she mentioned.
Wait, I will confirm in a while. I will just
Let the
check
record
if it's the same.
Let the record show that the witness is comparing his cell phone with the picture.
Ito ho. Pareho ho, kaya lang hindi ho nakalagay dito yung number. Can we state the number that texted me?
Please state it for the record.
0920-946-8820.
He's giving the cell phone number of the DBM secretary, Your Honor.
Yeah.
Witness may
Your Honor,
answer.
if they already admit it, then
Witness may answer. Let him to complete his testimony.
Mr. Witness, paano nyo po nalaman na ito po ang cellphone ni Secretary Abad?
Pag may kailangan ho ako, diyan ko ho siya tinetext. In fact, noong hindi pa ho siguro siya galit sa akin, noong second tranche ng PDAF ng 2010, yung unang PDAF ko, may nag-text ho sa akin. Sabi sa akin, please pick up your PDAF at the Speaker's office. So pumunta na, siyempre, first term ko ho na congressman, hindi ko ho inutusan yung staff ko. Excited ho ako. Ako mismo ang kumuha ng SARO. Ang sabi, please pick up your SARO.
Please speak slower, Mr. Witness, so that the stenographer can capture your testimony.
Okay, sabi ho, please pick up your SARO at the Speaker's office. So dahil ho ako ay first term congressman, excited ako. Ako mismo kumuha ng SARO. So pagkatapos nun, sabi ko, who's this? At tinanong ko pala una, who's this?
Paano nyo po tinanong yung who is this?
Text din ho. Sabi ko, who's this? Sabi, okay. Secretary Butch Abad.
Yun po ang reply doon sa text ninyo?
So sabi ko, thank you. Tapos magmula nun, pag may mga kailangan ho ako, dyan ko ho siya tinetext sa number na yan.
I think there is no problem about the telephone number of the DBM secretary. Is there? Do you deny it, prosecution?
I do not exactly have any idea as to the number of the DBM secretary.
You do not know?
I do not know, Mr.
All
President.
right.
Okay. Ano pong ginawa ninyo matapos nyo pong matanggap itong text message na ito? I withdraw the question. Ito pong text message na ito, may nakalagay po dito na speaker. Sino po ba yung speaker na binabanggit dito?
Speaker Sunny Belmonte. Isa lang naman ho ang speaker namin sa House of Representatives.
Meron din pong binabanggit dito na Pinoy. Sino po ba yung Pinoy?
Yan ho ang alam ko, yan ho ang tawag ng karamihan ng mga Pilipino sa ating Pangulo, Presidente Noynoy.
Matapos niyo pong matanggap itong text message na ito, na nagsasabi na kailangan yung makipag-usap sa Presidente, ano pong ginawa ninyo?
Objection, Your Honor, misleading.
Let him answer.
He should makipag-usap sa Presidente.
Counsel, ano ba ang kaugnayan nito sa kasong ito?
Opo, the witness, Your Honor, is testifying, Your Honor, as to the pressure that he received for the approval, Your Honor, of the impeachment complaint against Mercedes Gutierrez.
And what is the connection of that with this case?
We are obviously proving, Your Honor, that there is a pattern or scheme or plan, a modus operandi, Your Honor, with the majority, Your Honor, in the House of Representatives to intimidate, Your Honor, or exert undue influence upon their other members to approve their measures, such as this impeachment complaint filed against Chief Justice Renato Corona.
Your Honor, we have to object to that because may we be allowed, Your Honor, to state the reason for objection. This witness did not sign this complaint, Your Honor. So now he's saying that he was intimidated, but he did not sign the complaint. So in the matter of the impeachment case against the Chief Justice, his testimony as to the matter of the Mercedes Gutierrez has no relevance here, Mr. Speaker.
No, Your Honor.
Mr. President.
Mr. President, I beg to disagree. It's very relevant, Your Honor. It is interconnected, and the rules of evidence allow a party to present proof on a pattern, plan, and scheme.
We will give the defense all the leeway to prove their case.
Thank you, Your Honor. So, ano pong ginawa ninyo matapos nyo pong matanggap itong text message na ito?
Pinakita ko ho sa mga media doon sa sa Congress, yung text message. Para pakitang iniipit talaga ako.
Hindi po kayo nakipag-usap kay Pinoy? Kay Presidente Aquino?
Paano ko naman ho kakausapin yun?
Yun po ang nakalagay sa text message, hindi po ba?
Yun ang nakalagay, pero wala naman ho akong paraan at lakas na loob na kausapin yung
Bakit
Presidente.
po ba? Ano po ba ang rason? Bakit po hindi kayo makaharap?
Presidente ho yun eh. Ako ho ay isang first-term congressman. Hindi naman kami malapit. Though, siguro you can say that we're acquaintances. So, hindi ho ako naglakas ng loob na gawin yun. Ang naisip ko lang is pakita sa media na talagang iniipit ni Butch Abad yung aking PDAF.
Sinabi niyo po na kayo po ay pumunta sa media tungkol po dun sa text message na to. Ano po naging tugon ng media sa inyo?
Hindi, linabas ho nila yung text message na yon, ngunit never ho tinanggi ni Secretary Abad na nanggaling sa kanya yung text message na yon.
Meron po ba kayong kopya ng sinasabi ninyong nilabas ng media yung text message?
Meron po.
Meron po kayong kopya dyan?
Meron po.
We have pre-marked, Your Honor, newspaper clippings of the witness on this alleged matter in his testimony.
What is the marking?
Marking Exhibit 79 up to 87. May we request for an admission?
We admit, Your Honor, as to the matter of publication.
All right.
Okay. Ginoong testigo, ano po ang naging ano po nangyari matapos po nitong press coverage na nangyari po sa text message na pinadala sa inyo ni Secretary Abad?
Wala po. Inintay ko na kasi magba-budget briefing na ho ng August 1 at ang unang ahensyang haharap po ay yung DBM. Sabi ko, intayin ko na lang doon si Secretary Abad para doon na lang kami mag-usap sa budget briefing. So, noong August 1, ako ho ay 9:30 ho dapat yung budget briefing. 8:30 pa lang, pumunta na ho ako doon. Kasi ho, sa Congress, pag Committee on Appropriations, pila ho yan. Kung sino unang dumating, siya unang magtatanong. So, ginawa ko ho, pumunta ho ako ng 8:30. Sana ho, para ako maging unang magtanong. Ngunit, pagdating ko doon, pangalawa na ho ako, may nauna pa sa akin.
Ito pong sinasabi ninyo na kayo po ay nagpunta sa media para sabihin that sa budget hearing nyo po i-confront si Secretary Abad. Meron po ba kayong kopya ng mga press clippings nyo nito?
Meron ho, pero liliwanagin ko ho. Dito ho sa sinabi kong I will just face off with Secretary Butch Abad in the budget hearing. It was not a press release. I was interviewed because I think based on the news report, ang sabi ho ng minority ay magbo-boycott sila ng budget briefing. So ako ho ay dahil hindi pa nga rini-release yung kanilang saro. Tinanong ho ako kung magbo-boycott ako. Sabi ko, bakit ako magbo-boycott? Yan na nga yung pagkakataon na matanong ko si Secretary Butch Abad, bakit hindi linalabas yung saro ko? So hindi ho ako nag-boycott. Pumunta ho ako doon.
Salamat po. Dala niyo po ba dyan yung mga press clippings yun, yung pong press news clippings about the interview na ginawa sa inyo?
What is the utility of this press clipping? The witness already answered that he was going to meet with Secretary Abad.
Well, just as part of his testimony, Your Honor, that he was interviewed by the media, just for that purpose,
But what
Your
is
Honor.
the relevance of that interview? You're trying to prove that he's not that he's credible with a corroborative
yes, Your Honor.
statement.
Yes, Your Honor.
Is there a need for that?
Your Honor, just to prove that he is not He's not inventing, Your Honor, the story that he actually was interviewed by the media. Your
All
Honor.
right. Proceed.
We have pre-marked exhibits 88 to 93-A. Will the prosecution admit the press clippings for this?
Yes, Your Honor, press releases of the witness.
No, Your Honor, it's not a press release.
No.
The last one, it's a reply to the questions of media. Kasi ganito ho yan, Your Honor. Sinabi ho, magbo-boycott yung minority. Tinanong ho ako kung magbo-boycott ako. Ang sabi ko, hindi ako magbo-boycott at haharapin ko nga, yun na nga ang pagkakataon na makausap ko si Secretary
We
Abad.
will admit the matter of publication.
All right.
Okay.
Admitted. So,
Mr. President.
Our next question, witness, Counsel.
Mr. Witness, doon po sa budget hearing, ano naman po nangyari na?
Nagulat ho ako dahil 8:30 ho ako nahandon. 8:45 nag-text yung staff ni Speaker Belmonte. Sabi ho sa akin, nahandun na ho yung sayo ko. So, bago ko makausap si Secretary Abad ng 9:30, before 9, rinilis na ho yung mga sayo ko.
May kopya ka ba nitong mga saro na sinasabi ninyo?
Nandito ho, dated July 27 ho yung mga saro.
Ito pong mga saro na to have been pre-marked as our Exhibit 94 to 103-A. Will the prosecution admit that these are the copies referred to by the witness?
Gladly.
Okay.
Mr. President, while they are marking...
you record the numbers of the exhibits.
While they're recording the numbers, Mr. President, may we move for a suspension of the trial for 5 minutes?
All right. Trial suspended for 5 minutes.
Okay, Professor, anong direction natin dito kay Congressman Tovich? Bakit hindi naman mag-object yung prosecution kung nakikita na ni Presiding Officer Enrile na parang wala yatang, di ba? Parang walang kaugnayan dun sa impeachment.
Di tayo sanay
Oo, ni Corona.
Alam mo, sana may sagot ako. Wala akong sagot dyan kung bakit hindi nag-object. So, totoo lang, pinag-uusapan natin.
Baka dahil congressman din.
Baka wala akong sinasabing ganyan.
Tsaka parang halatang may camaraderie sila, ni Fariñas,
Ay, mo nun, make love not war. I don't know. Pero, ang una pumasok sa isip ko kanina, what cannot be done directly is now being done indirectly.
Meaning ito yung pagdeklara na defective itong mga article?
Naalala nyo, there was antagal nung diskusyon kanina about presentation of defense, on affirmative defenses, bakit hindi pwede, bakit ganyan, etc., etc. Tapos ngayon, yung first witness nila was for what purpose? To prove the factual basis of paragraphs 1 to 15 ng prefatory statement ng kanilang answer.
Yung sagot ni Corona dito sa impeachment.
Correct. Yung answer nila, alam natin na nag-submit sila ng sagot niya. Di parang yun din. Diba?
Bakit hindi nag-object ang
yun ang hindi ko alam.
They could have objected.
Oh yes, sabi ko nga, wow, this could have been more interesting.
Okay, dun sa sinasabing modus operandi o pattern ng House of Representatives, no? Sa kanilang mga miyembro, parang patungo na ito dito sa pagpirma, no? Dun sa impeachment complaint.
Mukhang ganon.
Dahil nangyari na pala ito dun kay Ombudsman Mercedes Gutierrez. Yung ganong, pampabraso bang matatawagin na pag hindi ka pumirma pabor, apektado yung iyong PDAP o pork barrel.
Yun ang pinapalabas, no? Which goes into what was objected to or what was already denied by our impeachment court na sana i-prove. Na gusto naman marinig din ng lahat ng tao. So ngayon, nagawa din. Wala namang objection. Mukhang ganun nga. Although I'm not sure if that's a pattern na.
Kasi isang case pa lang ang pinag-uusapan.
Correct.
Ito Mercedes Gutierrez.
Hindi ko alam kung pattern na yun. Ewan ko. But ang nakikita natin is na-expose ngayon.
Kasi sabi niya, nag-vote siya ng no eh. Ayun, pinahirapan siya sa kanyang PDAF.
Linabas din naman.
Oo.
Natagalan lang.
Matagal lang.
Ewan ko na.
Tapos ang isa pang naging observation natin, the defense finds itself on the receiving end naman of the negative comments of the impeachment court, no? So kanina napansin natin si Senator Miriam, Senator Joker Arroyo stood up and opposed itong move na nga ni Justice Cuevas na i-declare defective itong impeachment complaint. So nakikita natin medyo the tide is turning naman.
Totoo naman. And we always thought that the senator judges naman, pag nag-comment sila, pag gumawa sila ng clarificatory question question kung sino man yung nagpipresenta ng ebidensya. Hindi ibig sabihin na porke nagka-clarificatory question ka o nagko-comment ka,
pro ka na o antay.
Oo, sang-ayon ka na o di ka na sang-ayon na may kaya nga nandidinig. And true, that is a very good observation. Mukha ngang nakikita natin na yung mga senator judges magpapakita ng independence.
Although kanina, medyo na-offend si Senator Drilon sa mga sinabi ni Justice Cuevas.
I can understand why. Because it was a statement na medyo nagbibintang agad kay Senator Drilon. Kasi para sa prosecution ka, mas matatanggap ko pa yan.
Extension.
Yung ganun, which is uncalled for naman. Don't call any senator judge na outrightly kakampi dito.
So consistent nga sa direksyon na questionable itong articles of impeachment. So therefore, dapat ibasura ito at hindi na marinig itong panig ni Corona.
Ang gustong gawin, tinanong kanina ni Senator Arroyo, no? Kay Justice Cuevas, ano ba talaga ang gusto ninyong mangyari? At the end of the day, na-dismiss namin to pag napatunayan nga na ganyan. Hindi ho. Tama naman, hindi pwede. Kasi hindi pwede ang mga motion to dismiss na ganyan sa mga impeachment. Pero pupunta yon sa mga impluensya, sa mga senator judges kung paano sila boboto. Kahit na impeachable to, mambira naman, mukha namang dapat pala, hindi sinampa to. Pwedeng ganun. Yun ang gusto nilang ipalabas. Nabanggit nga kanina, tinanong ni JPE, ano ba talaga ang gusto niyong palabasin? Motive? Yes, Your Honor. Motibo. Bakit ba final ito in the first place? Duda ang
politika
mga motibo ng pag-file nito. Yun ang gustong ipakita ng depensa.
Pero ano naman ang relevance nitong usapin tungkol sa mga PDAF, pork barrel, noong panahon pa ng impeachment ni Mercedes Gutierrez? Anong kinalaman yun po dito sa Articles 2, 3, and 7 ni Corona?
Yun ang dapat na makita ng mas klaro, no? Ang gusto nga sabihin is yung motibo. Bakit nag-file ng complaint? Mukha pa lang, it is motivated by something else.
But this is only one congressperson speaking. So, he cannot speak for all the 188 who signed the complaint. So, where are we going with this?
By implication na yan. Parang sinasabi niya, kung nangyari sa akin, nangyari din sa iba. At naiva ko bago ko noon. I was a neophyte congressman, hindi ko pa alam ang mga kalakaran. Yun yung mga lumalabas sa kanya sinasabi. Kaya kung pwede nangyari yon, you can imagine kung ano nangyayari doon sa mga representatives na matagal na dito.
Okay, babalikan natin ang diskusyon. Samantala, tuloy-tuloy ang ating balitaan dito sa GMA News TV.
Ang News TV Live ihahatid sa inyo ni Chino Gaston. Chino.
Arnold at Vicky, sa umanong human rights advocate ang naghain ng ethics complaint laban kay Senadora Miriam Defensor Santiago. Kaugnayan sa umano'y pagbitaw ng senadora ng di magandang salita laban sa prosecution sa impeachment trial. Inihain ni Socorro Uncle Bob Guatlo Jr. ang reklamo sa opisina ng Senate Ethics Committee Chairman na si Senador Alan Peter Cayetano. Nagpakilala si Guatlo bilang tagapagsalita ng grupong Born Free Coalition for Truth and Justice. Nais daw ni Guatlo na mag-public apology ang senadora kaugnay sa insidente. Samantala, hindi sumipot si dating NBI Director Magtanggol Gatdula sa preliminary investigation ng kasong kidnapping at extortion laban sa kanya. Ayon sa 3-member DOJ panel na pinangungunahan ni Assistant State Prosecutor Juan Pedro Navera, may inihaing petisyon noong Biyernes si Gatdula para ipatigil ang proceedings kaya hindi ito dumalo sa pagdinig ngayong araw. Dumalo naman ang iba pang akusado kasama ang kani-kanilang abogado tulad din ng NBI Security Management Division Chief Mario Garcia at Virgelito Gutierrez. Naghain ng 3 mosyon ng kampo ni Gutierrez sa DOJ panel para ibasura ang kaso at ipatigil ang investigasyon. Git ng kanyang abogado na si Attorney Romy Esmero, walang naganap na pagdukot at pangingikil dahil legal na operasyon ang ginawa ng kanyang kliyente. Dumating din sa preliminary investigation ang nagrereklamong Japanese national na si Norio Ohara. 10 araw ang ibinigay sa kanya ng panel para makapagsumite ng komento sa mga mosyon na inihain ng mga akusado. Sa March 21, muling ipagpapatuloy ang investigasyon. Sa iba pang balita, nahuli na ang 2 sospek sa panggahasa at pagpatay sa batang 7 taong gulang na natagpuan sa isang sapa sa Parañaque. Dinala ng otoridad ang 2 sospek sa pagdukot at pagpatay kay Clariza Pizarra sa Parañaque Fiscal's Office bandang alas 11 kaninang umaga. Natagpuan ng labi ni Pizarra na naaagnas at lumulutang sa isang creek sa barangay San Dionisio sa Parañaque noong March 5. Kasong rape with murder ang isinambang kaso laban sa dalawang suspect na may edad 14 at 17 taong gulang. Pero dahil menor de edad, ipinaubayan na ng pulisya sa piskalya kung itutuloy ang kaso laban sa kanila o ibibigay sila sa DSWD. Sabado ng gabi nang bumagsak sa kamay ng Parañaque Police ang dalawang suspect. Araw kung kailan ring inilibing ang biktima. Lango raw sila sa solvet nang isama nila si Clarissa sa tabing sapa at doon halinhinang ginahasa. Pagkatapos ay itinulok nila ang biktima sa sapa na may hanggang leeg ang lalim na naging dahilan para malunod at mamatay ang bata. At yan po ang iba pang malalaking balita sa oras na ito. Para sa News TV Live, ako si Chino Gaston. Balik sa inyo Arnold at Vicky.
Maraming salamat, Chino Gaston. Mas maganda pa yung balita ni Chino. Saan nangyayari sa... Hindi, Professor. Balikan natin si Professor Dario. Hindi naman. Hindi, kasi kawawa naman yung bata.
Ang ganda ng bata, ang ganda.
Maganda siya. Maganda. It doesn't matter kung ano yung kanyang ayos. Nobody is
nakaka-stun, nakakaiba ng mood. So, anyway, ito
balikan natin impeachment.
Pero yung unang binalita ni Chino, no, yung tungkol sa ethics complaint laban kay Senator Miriam Defensor Santiago. Ano bang maaaring mangyari dito sa ethics complaint na ito?
Hindi lang 'yon. Ang narinig ko is it has become a human rights issue. 'Di ba? Hindi
public apology.
Not so much siguro na bilang miyembro ng Kongreso, dapat may kung hindi ginawa niyang human rights issue. Well, sa totoo lang, nobody deserves any disrespect. Pero kilala naman natin si Miriam, she gets passionate. Well, I don't want to comment on why she said certain things.
Wala na naman sa record ng ano yun.
Ano bang mga kaparusahan?
Ano yung tinanggal?
Na-strike out na, yung GAGO.
Kaya hindi natin alam yun.
Nag-move na si Congressman Parinas na naalisin sa record ng Senado.
Dito sa mga ethics complaint na ito, ano yung kaparusahan? Kung let's say, guilty.
Pwede, oo. Pwedeng sabihin, huwag mo nang ulitin. Ganon din yan.
Hinihingi nga public
apology. That's right. It's about behavior or conduct.
Actually, kanina nga binabagi si Joseph na may ilalabas ng ruling kaugnay na isa pang contentious act Hindi natin alam kung kanino yun. Hindi pa. Pero isa lang naman ang pending pa naman yung naging pahayag ni Attorney Roy, no? Na kung saan may 100 milyon na umano'y iniaalok dito sa mga senator judge. Yun yung pending na kung contentious ba itong pahayag na ito ng prosecution sa isang press conference sa pangungunahan ni Attorney Roy.
Siguro, Professor, on that note, no, pwede natin pag-usapan din yung tungkol dito kay Attorney Vitaliano Aguirre. Do you think they went easy on him at medyo kumambyo sila at nagdesisyon na lang pagsabihan itong si Attorney? Una kasi, di ba, talagang unanimous sila na
dalawang gabing tulong.
Pero biglang kumambyo sila and they reached the decision within 2 to 3 minutes without Miriam, of course, around. So, you think they decided to go easy on him because kung let's say sinight nila in contempt, paano naman nila iruruling itong 100 million peso bribe na allegation itong defense to make this is very small compared to that infraction?
Number one, hindi nila binalik yung contempt charge. They still cited in contempt. Ang pinag-uusapan lang is kung ano yung magiging ipapataw na penalty.
Okay.
Hindi totoo na hindi siya pinatawan ng penalty. Pinatawan siya. Reprimand nga lang. And that is penalty in itself. Kasi, kahit na admonition lang, that is a penalty. Sabihan ka ba naman, ikaw huwag mong ulitin. Ano yung wag uulitin? Ibig sabihin, meron siyang ginawa na hindi tama, na wag ulitin.
So, nasa record na niya.
Kaya lang yung range nung mga penalties kasi from admonition or reprimand to, pwede siyang i-detain, i-imprison, maybe within the confines of the Senate. It was the choice now of the senators to choose, yung choice nila, alin doon sa range ng penalties, and that's what they chose.
Okay. Professor, gusto ko lang balikan yung pagkaka-recess nitong impeachment body ng 1 week, pero hindi naman nag-recess si CJ Corona at umikot nga sa ilang mga member ng media, no?
Ayan.
TV, radio, pati sa print. Anong epekto nito gayong itong direction ngayon ng defense panel parang huwag na nga ituloy, ano? Itong dahil kino-question nila yung nullity and yung pagiging void nitong impeachment articles na ito. Pero narinig na ng publiko yung ilan sa mga sagot sa akusasyon nitong si Chief Justice Corona. Bagamat hindi ito under oath, hindi ho ba? So may epekto ba ito sa ongoing trial?
Epekto, nabanggit na natin.
Sa publiko? Okay.
Nabanggit natin, dalawang klaseng trial yan.
Okay.
Di ba?
Loob
Doon
at
sa
labas.
impeachment court at saka sa public, in the court of public opinion.
Ayun.
Sa court of public opinion, abay, napakalaki ng epekto. Napakamalumanay magsalita ni Chief Justice. Narinig na ng lahat yung gusto niyang sabihin. Nag-form na sila ng opinion. Alright? Narinig din natin kung ano yung mga sinabi ng mga kaanak ni Mrs. Corona. So, nagpo-form na yan ng mga opinion sa mga isipan. Pero hindi yan ebidensya. That should not form part, it does not form part of the evidence na i-consider ng impeachment court. Although, nabanggit na rin natin, the senator judges will make a decision. Magko-convict ba sila or mag-acquit ba sila base sa dalawang bagay. Yung ebidensya at hindi ito ebidensya at yung kanilang konsyensya or ayon sa paniniwala nila. At dahil nga, ito ay yun, nakita na ng buong madla kung ano yung depensa na hindi ebidensya sa ayaw natin at sa gusto dahil tayo naman ay tao, magsisip in na yan sa consciousness ng ating mga senator judges. Inevitably, hindi natin sinasabing masama, hindi natin sinasabing hindi dapat, pero inevitably, dahil mga tao yan, meron na yan, konting seed na naitanim. Maganda nga kung mapresenta si Chief Justice nitong mga pagkakataon nito. Pero cross-examine din siya.
May plano yung prosecution sa rebuttal, patawag itong mga kamag-anak ni Miss Corona. Pero kanina nakausap ko yung tagapagsalita impeachment court, si Atty. Cruz, sinasabi niya na malayo sa article of impeachment itong Basa Guidote Enterprise Incorporated. So, malabo daw na payagan ng impeachment court na humarap itong si Ana Basa o maging si Sister Flory dito sa impeachment
court.
Dahil
collateral na nga yan. Kung ano yung away nilang pamilya, hindi naman yun ang pinag-uusapan sa impeachment court. Bakit pinag-uusapan? Dahil naalala natin doon sa Salen, meron doon sa liabilities portion.
11 million.
Correct. Yung meron daw siyang liability dahil may hiniram siyang pera. Ang tawag nila is cash advance. Kailangan pa rin bayaran niya. So, ito nga ang kanyang mga assets. Meron din siyang liability. 11.5 nga ang sinasabi. Paano ka nagkaroon ng liability? Dito, sa Basa Guidote. Nakalagay pa doon, my wife's company pa. Parang, how valid is this? Kung pinapakita nga kung ano yung mga assets, kung totoo nga, kailangan di ipakita, totoo ba ang mga obligasyon? Dahil paano natin malalaman? Remember ang ating assets, tas liability sa dulo, ano yung pinag-usapan?
Yung net worth.
Correct. Kaya valid up to that point.
I see. So in that case, pwede ba nilang ipatawag pa rin ito sina Ana Basa and Sister Flory to prove, kasi sabi nila, naku, wala tayong kinalaman dyan sa utang na yan. Hindi kami familiar dyan sa utang na yan. And you would have to show us some documentary proof na talagang may kasulatan ba yan na hubiram talaga siya ng 11 million. Baka nagiging cover-up lang tayo dito sa Basa Guidote.
So, ang nagiging issue doon is within themselves. Yung bang pera na yan, hiniram without our authority. Usapan na nila yon. Meron bang board of directors noon na nag-meet para magpahiram? Sa loob na nila yon. The point being, meron pa lang Basa Guidote Enterprises Incorporated or company. Meron pa lang mga naging negosyo to at meron pa lang subject yung negosyo. Meron pa lang pera. So,
pero whether or not alam nila kung nagpautang o hindi, labas na yon dito sa kaso.
Sa impeachment, directly hindi. Na nagiging collateral.
Kasi nga, bakit yung utang dineklara?
Mismo.
Diba? Yung 11 million na bayad na. Pero nakadeklara sa liabilities. Pero yung bank account na may 30 million pesos, sinasabing, ba't niya idedeklara? Bahagi ng korporasyon. So, hindi kanya yon. So, yun ang tanong ng marami. Ba't yung utang nakadeklara, pero yung pag-aari ng korporasyon ay hindi dinedeklara, gayong ito ay sinasabing sa kanyang may bahay naman daw.
Correct.
So, pag-uusapan niya kung conjugal ba yung pagdeklara niya ng SALN o hindi.
Sa totoo lang, yung SALN na yan, joint declaration.
O, joint declaration.
Not
Pero
necessarily tungkol sa conjugal property.
Pero napansin din sa SALN na hindi naman nakapirma si Mrs. Cristina Corona. So,
magandang i-raise yan pag pinaupo si Mrs. Corona. Kaya yun yung exciting part, I guess.
I guess speaking of exciting parts, one thing that happened over the past week is that the Senate decided to admit as evidence itong mga bank accounts ni Chief Justice Corona. So how important is this to the case for the prosecution? Siyempre, pumapalakpak ang tenga ng mga prosecution when they heard about this. Pero why is it so important to their case?
Iba yung pag-admit sa weight. Alright? Pwede kasi ang isang piece of evidence na tinatawag nating admissible, para sa mga minds, sa mga isipan ng mga nagdidesisyon, hindi naman ganun kabigat. So, dalawang issue yan. Pwede ring napakabigat, kaya lang hindi admissible. Pwedeng admissible, hindi ganun kabigat. Dito, inadmit, ibig sabihin, yes, Senator Judges, pwede ninyong gamitin yan sa inyong pag-consider kung mako-convict ba siya or maa-acquit. Pero, dahil kino-consider nyo ngayong ebidensya, mabigat ba? Meaning, kung ano man ang pinapakita ng mga ebidensyang yon, impeachable offense ba? Yon ang gustong makita.
Okay, Professor, ito, balikan na natin ang...
Nag-uumpisa na ba?
Impeachment Court, bumalik na si Presiding Officer Juan Ponce Enrile.
Trial resumed.
Your Honor,
Counsel, you continue with your examination.
Your Honor, we do not want to take advantage of the absence of a prosecutor, Your Honor. They are not yet present. The prosecution is not yet present, and we would not want to take advantage of
All
that,
right.
Your Honor.
Where is the prosecution panel?
May we suspend the trial, Mr. President, until they arrive?
Trial suspended for 1 minute.
Nasa na yung... Okay, hinahanap po yung member ng prosecution.
Pero medyo relax sila ngayon, ano? Nakikita natin pag hinahagip sila ng camera, nakaupo lang, hindi katulad dati, no? Medyo talagang on their toes parate.
Kaya?
Oo, at saka bihira lang sila mag-object din, ano?
Dahil kung gusto nila maging strict to Your Honor, we observe that the prosecution panel is not here, we move to cite them in contempt. Oh, di ba?
Kung wala pa.
We don't like to take advantage. Well, friendly. Today is a very friendly day.
Oo nga.
Sa bagay, sa ordinaryong korte yan, kung mahigpit yung nakaupong
Oo naman.
naman. Parang sinasayang mo ang oras ng korteng ito.
Ando doon na yung judge
Kaya nga.
Ando doon na yung presiding judge.
Ayan na sila.
All-majority caucus meeting. What did you do on that date mentioned in the text, December 12,
Go straight
2011?
to the point. Did he attend the meeting?
Yes. Did you attend that meeting?
Yes, Your Honor.
And what time did you arrive at this meeting?
It was in the text message of the invitation, since it was said that we have to be there at 2:30. So I made sure that I was there on time at 2:30, Your Honor.
Were there already people in the venue when you arrived?
Yes, Your Honor. There were already people in the venue.
Who was presiding the caucus?
Your Honor, it hasn't started. It didn't start at 2:30, Your Honor. So when I went in, it hasn't started yet, Your Honor. At 2:30.
When did it start?
It started, estimate, Your Honor, maybe 3 o'clock to 3:10, Your Honor. That's an estimate, Your Honor.
And who was presiding?
Your Honor, it was presided by Speaker Sonny Belmonte, Your Honor.
All right, proceed.
Okay. What did the speaker say?
The Speaker said, we will impeach the Chief Justice today. Chief Justice Corona is a protege of GMA. And wala siyang gagawin kung hindi proteksyonan si GMA. At, Your Honor, I'm distracted.
Please continue, Mr. Witness.
Sorry, I got distracted by the chattering of the prosecution.
May I request the prosecution to keep quiet while the witness is testifying?
We're quiet, Your Honor.
Yeah, don't heckle the witness if...
We are not, Your Honor.
All right.
No, they were heckling. They were just talking among themselves and I could hear it.
Yeah. All right, Mr. Congressman, proceed, please.
Where was I, Your Honor?
You were mentioning the statements of the Speaker
okay.
at the start of the caucus.
Speaker Sonny Belmonte said, we are here to impeach Chief Justice Corona because he is a protege of GMA and he will protect GMA. At siya'y magiging hadlang sa magagandang layunin ni Presidente Noynoy. Isipin nyo, 6 na taon magiging presidente si Presidente Noynoy kung yung Chief Justice lahat na lang ng kanyang magandang hangawin tututulan ng Supreme Court, ano naman ang magagawa ng Presidente? Yan ho ang number 1 na sinabi niya.
Meron po bang number 2?
Number 2, ang sabi niya...
Mr. President, may we object? Because
What is the ground of the objection?
Your Honor, a caucus, as we all know, is a meeting of all members and it is akin to an executive session, Mr. President. And in the same manner that the Honorable Senate...
Are you claiming legislative privilege?
Yes, Your Honor, with respect to the whatever happened or transpired in the caucus, because under our rules...
Just go to the point.
Yes, Mr.
That is not covered by the rules. The witness may answer.
Please proceed. Ano po ba yung number 2 na sinabi ni Speaker?
Ang sabi ho ni Speaker ay si Chairman Junjun Tupas will present the grounds for impeachment. Number 3, yung mga gustong bumoto, pagkatapos ng presentation, yung mga gustong bumoto, yung mga ayaw bumoto, wag bumoto. Ngunit ang number 4 na hindi ko nagustuhan, ang sabi niya, this is non-debatable. No questions will be entertained.
Bakit niyo po hindi ito nagustuhan?
Bakit?
Bakit po?
Siyempre po. Kami ho ay deliberative body. Lahat ho ng ginagawa namin sa Kongreso ay pinagdidebatihan dahil ho, siyempre, you will get the best result out of discussing a proposed measure. No? Tsaka, para sa akin, ang dating sa akin, diretsahan, nung pag pinagdugtong mo yung sinasabing pumirma na yung pipirma at no questions will be entertained, it's a veiled threat.
Ano po ba mga naging reaksyon kung meron po nung mga tao na nandun sa caucus na yun?
Dalawa ho ang nakapagsalita pa bago mag-present, no? Isa ho dyan, si former Senator Biason. Sabi ni Senator Biason, ano ba naman kayo? Mataas ho yung boses niya. Ano ba naman kayo? Magpapatawag kayo ng caucus, walang agenda. Yung media sa labas, alam na impeachment ang pag-uusapan. Ako hindi ko alam. Papapirmahin nyo kami ng impeachment, wala pa akong nababasang kopya ng impeachment complaint. Tapos, tumalikod ho siya, di na siya nag-intay ng sagot, tumalikod, tapos hindi ko alam kung lumabas o kung saan nagpunta. Pagkatapos ho nun, ang susunod na magsalita ay si Congressman Rufus Rodriguez. Sabi ni Kong Rufus, paano yun kung meron kaming clarification tungkol dun sa PowerPoint presentation? Hindi ba ho kami pwede magtanong? Sinagot ho ni Speaker Belmonte, ang sinagot lang ho ni Speaker Belmonte ay si Congressman Biason. Sabi niya, pwede kayong kumuha ng kopya mamaya sa likod dahil ginagawa pa. Yun ang sabi niya kay Congressman Biason. Pero si Congressman Rodriguez, ang sumagot ho kay Congressman Rodriguez ay si Congressman Boyet Gonzales. Ang sabi niya, kung gusto mo magtanong, doon ka magtanong sa floor. So pagkatapos nun, nagpresenta na ho si Congressman Tupas ng PowerPoint presentation.
Napanood niyo po ba yung PowerPoint presentation na ito?
Opo.
Ano po ang mga nakalagay dun sa PowerPoint presentation kung naalala niyo po?
Pinaliwanag ko ni Chairman Tupas, ito ang grounds for impeachment kay Chief Justice Corona. Katulad na sinabi niya yung article, tapos may nakasulat na mga bullet points, tapos may narrative siya. So, for example, Your Honor, Article 1, sinabi niya yung accusation, tapos dinarrate niya kung bakit. Yung Article 2, yun ho ang pinaka-famous na article, sabi niya, non-disclosure of SALN is a culpable violation of the Constitution. Number 3, sabi niya, yun ho yata yung tungkol sa pag-appoint sa misis ni Chief Justice Corona. Tapos yung 6 ho na article, parang isa ho ang presentation nun dahil ang sabi, ito ho ay a pattern of deciding in favor of GMA. Tapos yung 3 doon, ang sinabi, ay yung 2 doon, yung flip-flopping decision. So ganun ho yung pagka-explika.
Nandito po sa korteng ito, yung pong verified complaint for impeachment. Ipapakita ko po sa inyo to. Pwede nyo po bang sabihin kung ito po ang nakita ninyo doon sa PowerPoint presentation na sinabi nyong pinangunahan ni Representative Neil Tupas? Pakitingnan lang po ng mabuti.
Ito hong buong to?
Yung pong verified impeachment complaint lamang. Pakitingnan lang po.
Hindi, itong buong kakapal na papel?
Yan pong buong kapal na yan.
Ito hong buong kapal?
Yan po yan, yan po. Pakitingnan nyo lang po ng mabuti, yan po ba ang pinakita sa PowerPoint presentation? Let the record show that the witness is perusing through a copy of the verified impeachment complaint.
Hindi ho ganitong ang pinakita ho, Article 1, tapos may nakasulat ho, tapos narrative. Tapos Article 2, nakasulat ho yung allegation, tapos narrative ulit. So hindi ho ganitong kakapal na hindi ho mapa-PowerPoint ton bullet points lang ho yun eh.
Kayo po ba nabigyan ng kopya niyan, ng complaint na yan, nung nandun kayo sa presentation sa caucus?
Hindi pa ho, kasi sabi nga ni Speaker, ginagawa pa sa likod yung kopya. Nung humingi ho si Congressman Biason, sabi niya, wala kaming kopya, paano kami pipirma? Sabi niya, ginagawa, kubuha kayo ng kopya sa likod mamaya.
Doon po sa...
Ginagawa yung complaint. Yung articles of impeachment.
Hindi ho Your Honor, Mr. Senate President, hindi ho maliwanag. Kasi ganito ho, can I explain, Your Honor?
Oo. Sige.
Ang sabi ho kasi ni Congressman Biason, siya ho medyo galit ho eh. Kung mataas ho yung boses niya, pumasok siya, tsaka alam niyo, lumakad yun, macho ho eh. Sabi niya, lumapit sa mikropono, sabi niya, ano ba naman kayo, magpapatawag kayo ng meeting, walang agenda. Tapos, hindi ko na ho sasabihin yung sinabi niya sa ito. Mukha naman akong dito, yung media sa labas. Alam na impeachment pag-uusapan. Ako hindi ko alam. Tapos papapirmahin niyo kami ng impeachment complaint. Wala naman kayong kopyang pinapakita. Ang sagot ho ni Speaker is, ginagawa pa sa likod, kumuha na lang kayo mamaya. So I don't know what he exactly meant by ginagawa pa, Mr. President. I'm sorry, I could I could not answer it directly.
Yeah, correct.
Pakitingnan nyo lang po dun sa verified impeachment complaint. Nandiyan po yung grounds for impeachment. Pwede nyo po bang sabihin sa korting ito kung yan po ba ang pinakita dun po sa PowerPoint presentation?
Mr. President, object to this line of questioning because they are now going into the articles of impeachment, which has already been answered by the defendant, and this has been ruled upon already in the resolution of this honorable
He's
court.
just asking a question whether he read this impeachment, articles of impeachment. The witness may answer.
Hindi po.
Hindi po, ano. Wala po, hindi po yan ang nakalagay.
Maiksi lang ho yun eh. Bullet points lang ho eh. Article 1, tapos may bullet point doon, tapos narrative ho.
Okay. Yung pong sinabi nyong, tingnan nyo po dyan, ano, yung Article 1 na nakasulat po dyan, at saka base doon sa Article 1 na nakalagay po doon sa PowerPoint presentation, meron po bang pinakita sa inyong mga dokumento na sumusuporta dyan sa aligasyon ng Article 1 during the caucus?
Sa Article 1 ho, wala. Naka-flash lang yung title, tapos narrative.
Meron po bang pinakita sa inyong desisyon ng Korte Suprema?
Your Honor, object, leading question, Your Honor.
What was shown to you?
May answer.
Desisyon ng Korte Suprema?
Oo.
Wala po.
Wala pong
Sinabi
pinakita.
lang ho na may ang Article 1 ay sandali po, binabasa ko po eh. Wala lang, pinaliwanag lang niya na kinakampihan doon sa mga kasong may binanggit sa mga kaso, sinabi lang niya kinakampihan, pero kung sasabihin yung pinakita ba yung kaso o pinakita ba yung GR number or in-enumerate ba yung kaso, wala ho. Wala po.
Doon po sa Article 2, doon po sa PowerPoint presentation, meron po bang dokumentong pinakita sa inyo tulad po ng SALN ni CJ Corona o kahit na anong sertifikasyon? Meron po bang pinakita sa inyo noon? Nung ipinapaliwanag yung Article 2.
Pero witness ba?
Pinakita ho yung SALN?
Meron po bang pinakita sa inyong kahit na anong dokumento?
Wala ho.
Wala. Meron po, ipinaliwanag po ba sa inyo yung ibig sabihin ng Article 2?
In narrative, ang Article 2, it is a culpable violation. Dapat mag-disclose ang Chief Justice ng SALN. Pag hindi niya di-disclose yan, culpable violation of the Constitution. Ganun ho ang pagkasabi.
Yun lang pong disclosure ang sinabi? Meron pa po bong iba?
Non-filing and disclosure of the SALN ang sabi.
Yun lang po ang paliwanag in the PowerPoint presentation?
Opo, nakasulat ho, non-disclosure and filing of SALN. Yun lang ho. Pero kung tatanungin nyo kung pinakita yung SALN o may pinakitang certification ba na sinasabi na the Chief Justice did not disclose or the Chief Justice did not file a SALN, wala hong certification na ganun. At wala hong SALN na pinakita.
Meron po bang mga income tax return o transfer certificates of title? Maski po photocopy, meron po bang pinakita sa inyo?
Your Honor, sinabi ko na ho,
Wala,
pinakitang
maski na ano?
Kahit anong dokumento.
Puro paliwanag lang po yung nangyari.
Opo, narrative po, Your Honor.
Doon po sa Article 3, meron po bang pinakitang mga dokumento sa inyo?
Wala po.
Kahit na ano pong dokumento?
Sa lahat ho ng article, wala hong pinakitang dokumento. Ang pinapakita lang ho yung parang ano ba tawag dito? Parang bullet point, parang isang maiksing paliwanag, tapos sinasabi niya kung ano yung pinapaliwanag niya, kung ano ibig sabihin ng article na yon, Your Honor.
Ano po bang naging conclusion ni Congressman Neil Tupas matapos po yung PowerPoint presentation niya?
Hindi, sinabi niya na dapat impeach si Chief Justice Corona.
Kayo po ba ay sumang-ayon sa conclusion na ito?
Hindi po.
Bakit po? Hindi po ba pinaliwanag naman sa inyo? Hindi po ba kayo nakumbinsi nung paliwanag ni Congressman Neil Tupas?
Mr. Senate President, can I answer?
Yes.
No, because my answer will be that after the presentation, I was not convinced that there was probable cause. But you ruled earlier, so you might get mad at me.
Just answer and the court will make a ruling.
No, I don't want them to get mad, Your Honor. Because they were trying to convince us that there was probable cause. That's why there was a presentation.
Kayo po ba'y nakumbinsi? Were you convinced that there was probable cause?
Hindi ho ako, kasi ang pagkaintindi ko po sa probable cause yung probabilidad na ginawa ho ng akusado ang isang paratang sa kanya. Paano ho ako makukumbinsi kung wala hong dokumento o katibayan na pinapakita? Siyempre, para makumbinsi ho tayo, dapat makita natin, kunyari, non-filing of SALN, dapat ho, may certification na hindi ho siya nag-file ng SALN. Pero kung wala hong papakitang dokumento, hindi ako makukumbinsi na may probable cause.
So aside from not being able to read the complaint and not seeing these documents, was there any other valid reason for you not to sign the impeachment complaint? Was there any other consideration that you...
Dalawa ho. Number one, hindi ako makakapirma nang hindi ko po nababasa.
Opo.
Yan ho yung unang-una. Siyempre, kahit naman ordinaryong tao, hindi ka pipirma kung hindi mo nababasa. Number two ho, I felt it was an attempt, it was not a simple impeachment of the Chief Justice, but it was an attempt to control or to scare the Supreme Court. Kaya hindi ako pumirma.
Ano po, pakipaliwanag niyo po yung sinasabi ninyong an attempt to control the Supreme Court. Bakit niyo po nasabi yan?
Objection, Your Honor. The witness is already speculated.
It's an opinion.
Your Honor, kaya ko ho sinabing attempt ho, kasi yung unang attempt ho ay yung doon ho sa yung savings ng
stop. He's arguing with the chair, Your Honor.
What was this?
Mr. Congressman, the objection is sustained. So, kindly wait for the next question.
Sorry, Your Honor.
All right.
Meron lang ako tatanungin.
Yes.
Doon ba sa caucus ninyo nandun si Congressman Neil Tupas?
Your Honor,
nandun sa caucus si Congressman Neil Tupas.
Opo, siya ho nagawa ng PowerPoint.
Si Congressman Joseph Emilio Abaya.
Joseph Emilio Abaya.
Hindi mo natatandaan.
I cannot say a definite yes, Your Honor.
Si Congressman Lorenzo Artañada III. Nandun.
May manifest that is taking a long time to answer, Your Honor.
Marami ba kayo doon?
Madami po.
Mga ilan kayo nandun?
At the peak, kasi nung
Hindi, calculation lang.
Hindi, pinaka 120, 130?
Nandun.
Opo. Nung time na nahandun ako, Your Honor, Mr. Senate President, I was just there from 2:30 to about 4:10. So,
doon sa panahon na yon, marami,
mga 120 to 130. Pero umalis ho ako ng mga 4:10, Your Honor.
Nandun ba si Reynaldo V. Umali?
Ayun ho, sigurado ko malaking tao ho yun.
Nandun sa. Si Arlene J. Bagaw, nandun.
Nandun ho.
Nandun. Posibleng nandun si Congressman Abaya.
Posible ho, posible ho.
Posible rin na nandun si Congressman Tanyada.
Yes, Your Honor.
All right. Sige, proceed.
Sinabi mo that you were worried about the attempt at judicial control. Why were you worried?
Kasi ho,
Objection, Your Honor. Again, asking for
Your
an
Honor,
opinion.
the witness can explain.
That's an opinion, counsel. You're asking for an opinion.
No, I'm just asking, Your Honor, for his reason.
Precisely, you're calling. He's making that was his opinion. His surmise. It's not a question. It's not factual.
So,
reform the question.
Sige po. So, ito pong matapos pong magbigay ng conclusion po si Congressman Neil Tupas. Ano po ang nangyari doon po sa caucus?
Meron pa akong gusto magtanong. Hindi na ho pinayagan magtanong. Tapos, ang sinabi, the Secretary General will administer the oath and verify the complaints in front. Yun
Mr.
Ho.
Congressman.
Yes, Your Honor.
Nandun ka magsimula sa anong oras?
2:30 ho hanggang 4:10, Your Honor.
2:30 hanggang 4:10.
Yes, Your Honor.
So, sa Makatid, mahigit na 2 oras.
Hindi, Your Honor, 1.5 hours, Your Honor.
1 hour, 40 minutes.
More or less, Your Honor.
Oh, sige. At natapos yung power presentation nung nandun ka.
Natapos ho siguro, kung tama ho yung aking recollection, mga nagsimula ho kami, Mr. Senate President, at mga between 3 to 3:10, tapos siguro mga 20 minutes yung PowerPoint presentation sa mga 3:40 to 3:45. Tapos umalis ho ako ng mga 4 o'clock.
At prinisinta yung 8 articles of impeachment.
Opo, Mr. Senate President.
At inisplika kung ano yung mga PowerPoint na nakalagay doon.
Verbally, opo, Mr. Senate President.
Nag-explika doon sa bawat articles of impeachment.
Opo, Mr. Senate President.
Proceed.
So, nung matapos po, sinabi nyo, hindi na po pinayagang magtanong. Ano na po ang nangyari nung hindi na po nagkaroon ng tanungan?
Hindi, katulad doon ng sinabi ho na the Secretary General will be here to administer the oath and the verification. Pumila na yung mga pipirma.
Saan po pumila?
Doon ho sa kasi kung illustrate ko ho, nahandun ho si Speaker, doon ho nag-PowerPoint presentation, kaming lahat ho nakaharap doon. So doon ho sa baba ni Speaker, doon sa harap ho.
Mm-hmm. Ito po, ilan pong mga tao ang tansyan yung nakita nyo na gusto pong pumunta doon para pumila? Ano po ba ang naging sistema ng pagpirma?
Nakapila ho sila, tapos meron din hong nakakumpul doon sa pumipila, Your Honor. Ibig sabihin, there was, sa bandang likod, there was a straight line. Pero right in the table, nakapaikot ho yung nakapaligid yung mga ibang mga congressman, Your Honor.
Yung ba mga nasa linya ay yun din yung mga tao na nandun sa caucus?
Opo, Your Honor. Pero hindi ho lahat pumila kaagad, Your Honor. Yung iba nagkwekwentuhan sa gilid, tsaka yung iba siguro dahil mahaba pa yung pila, pinapauna ho muna.
Nakita mo po ba sila habang pumipirma?
Kung ang tinatanong nyo is the act of signing, hindi ko ho makikita dahil nakapaligid ho yung mga tao doon sa mismong taong po. Kung ako pumipirma, may mga nasa kaliwa, may nasa kanan, may nasa likod, may sumisilip. So, kung sasabihin mong actual na nakita kong pumipirma, hindi ho.
How far away were you from the place where they were signing?
Siguro, kung kayo nakatayo dyan, nahandun ho sa likod ni Senator, sa may kay Senator Bong Revilla o sa likod ni Senator Bong Revilla at ni Senator Ralph Recto.
Let the record show that the witness has demonstrated the distance of his position to the location where the signing took place, which in our estimate would be about 20 feet.
More.
30 feet.
Your Honor, yung nasa Andaya Hall kami, no? Nandun ho ako malapit sa pinto ng Andaya Hall at nahandun ho yung sila sa bandang harap.
Nakita nyo pong pumipila. Gaano ko po ba katagal yung isang tao bago po umalis dun sa pila matapos siyang pumirma? How long did it take? Kung maalala ninyo.
Yung tulad na nasabi ko kanina, hindi ko nakita yung kanilang pagpirma. Ang nakikita ko, pupunta sa harap yung isa, tapos aalis dun sa mismong gitna, either pupunta siya sa gilid, makikipag-usap po, or pupunta sa bandang likod. So yun ho ang tinatanong yung time.
Opo, yung pong time na yun, gaano katagal? Yung isang tao, gaano po ba katagal? 1 minuto?
Hindi ho. 20 to 30 seconds at the most. 20 seconds.
Mm-hmm. Ngayon po, ito pong naging action po ng impeachment against Chief Justice Corona. What other measures has been filed in Congress involving the judiciary, if you know?
Isa ho, meron hong...
Objection, Your Honor.
He's a member of Congress, Your Honor. He would know the measures involving the judiciary.
Will you clarify your question?
It's big, Your Honor. What other measures?
Yes, Your Honor.
Reform the question.
Yes. Mr. Witness, this after the signing of the impeachment complaint against Chief Justice Corona, are there other measures involving the judiciary in Congress which you know?
Leading, Your Honor, because he's
I'm
presuming that there were other actions, Your Honor.
I'm just asking, Your Honor, if
preliminary. Let him answer.
Your Honor, December... Pwede hong tignan yung notes ko?
Go ahead, Mr. Congressman.
The witness, Your Honor, is going over his notes. Let the
December 7 ho. December 7 was a Wednesday po, Your Honor. So, December 7, 2011, pinagbotohan ho sa Committee on Justice yung substance ng Del Castillo impeachment. Okay? Noong December 12 ho, 5 days after, 5 calendar days, but the next session day, ibig sabihin kasunod na session day, yun ho ang impeachment kay Justice Corona. Tapos, noong December 13, base ho dito sa news reports, which quoted Chairman Neil Tupas, sabi ho dito sa Inquirer tsaka sa Philippine Star, House Committee readies impeach Raps versus 2 more justices, Your Honor.
He's testifying on a newspaper report, hearsay, Your Honor.
Your Honor, he has already testified, Your Honor, on newspaper clippings in his possession, and there was no objection. So, I don't understand
That's
why
our prerogative. We cannot object to the other.
Let the witness answer. Anyway, that's a matter of record in the newspaper. It can be very...
So, uulitin ko lang ho, Mr. Senate President, Your Honor. December 7, 2011, pinagbotohan ho sa Committee on Justice yung substance ng Del Castillo impeachment alleging him of plagiarism.
Objection, Your Honor. It's not responsive because this is December 7 and the question is, pagkatapos, after December 12, was there an action?
He is already answering, Your Honor. How can he even object?
We're objecting,
There is
Your Honor,
already an answer propounded by the witness.
The answer is not responsive. It will be stricken out.
What was the question
The question, Your Honor, was what other measures, and it has been allowed, Your Honor, involving the judiciary as a preliminary question. And the witness now is explaining the other measures involving the judiciary, which is the impeachment complaint against Justice Del Castillo, And then after the impeachment of CJ Corona, Your Honor, there is a plan again to impeach 2 other justices. And his basis, Your Honor, now, he has shown to the court that there are news reports, Your Honor, for the 2 other justices.
Wait a minute. There is no indication of another action to impeach 2 other justices.
Yes, Your
Counsel,
Honor.
where did you get that information?
The witness has testified, Your Honor, has already mentioned, and he is reading, Your Honor, from the reports which he bases his observation.
No. My recollection of the answer of the witness is that prior to the impeachment of Justice Corona, the matter regarding the impeachment of Justice Castillo was taken up.
Yes, Your Honor.
And thereafter, what happened, Mr. Congressman, after the decision to impeach Justice Corona?
Si Chairman Tupaso na interview ng December 13 at lumabas ho sa Philippine Daily Inquirer at sa Philippine Star ng December 14 na may dalawa pa ho. 2 more SC justices would also undergo impeachment for alleged graft and corruption.
Well, anyway, let the witness answer. That can be rebutted by the prosecutors who are here and being named by the witness. Go ahead.
What is your proof, Mr. Witness, that there was such a decision to...
Is it already answered? It
asking,
was an interview.
It was in news articles, Your Honor.
Referring you to the impeachment of Justice Del Castillo, what is your proof that there was such a move of Congress?
The minutes of the December 11 meeting of the Committee on Justice, Your Honor.
I am showing to you the copy of the minutes of the December 7, 2011 Committee on Justice meeting. Is this the document which you are referring to?
The witness said December 11, Your Honor.
December 7, 2011.
Never mind about the date. The document will establish the date.
I stand corrected, Your Honor. December 7, yes.
Okay.
May we request, Your Honor, that this document be marked as our exhibit number...
Mark it accordingly.
113.
Mark it accordingly.
Do you have copies of the... referring to the intention of Congressman Neil Tupas to impeach 2 more justices? Do you have copies of that?
Wait a minute. What's the relevance of that?
Your Honor,
that question.
Your Honor, he has already answered that he read from newspaper reports that there were a statement from Congressman Neil Tupas that he intends to oust 2 more justices, and he has already testified on it.
There is already he read into a newspaper clipping.
Yeah, I just want to mark, Your Honor, the newspaper clipping which he read.
All right, mark it.
May we request that the 2 newspaper clippings which was read by the witness be marked as our exhibit 110 and 111.
What newspaper was that?
It's Philippine Daily. It's from the website of Philippine Daily Inquirer and
right.
Philippine Star, Your Honor.
All right.
Can I continue to answer his question?
Proceed.
Yes. What other measures?
He was asking what other measures. Before all of this was the was my disagreement to the putting of the savings from personal services of the judiciary to the MPBF. Tumutol ho ako doon, and it was on record. Tumutol ho ako na yung judiciary, yung 3 constitutional commissions, yung COA, COMELEC, at yung Commission on Audit, at panglima ho yung ombudsman, kasi ho doon sa proposed budget ng Congress, ang gusto ho, ilipat ho sa MPBF yung savings from vacant positions.
Ano yung MPBF?
Miscellaneous Personal Benefits Fund, Your Honor.
Sa budget?
Hindi, sa budget po. Yung pong savings on vacant positions, ang gusto ho doon sa House ay ilipat ho doon sa MPBF. Tutul ho ako doon dahil yan ho ay labag doon sa constitutional provision na ginagarantihan ho ang fiscal autonomy ng 5 ahensyang ito. Kaya ang ginawa ko ho, sumulat ho ako doon sa 5 ahensyang yon, tinanong ko ho kung magkano yung savings on vacant positions na ipinapalipat ng DBM sa MPBF, at nung natanggap ko ho yung sulat, sumulat ho ulit ako kay Chairman Abaya proposing an amendment, Your Honor, na wag hong ilipat sa MPBF yung savings ng mga ahensyang to, Your Honor.
Nabanggit mo...
May we register our continuing objections to this line of questioning about the budget and
you may.
other matters, Mr.
All right. Noted.
Nabanggit nyo po na meron po kayong sinulatan ng mga ahensya ng gobyerno, particularly the Supreme Court and the other constitutional bodies, Your Honor.
Yes.
Meron po bang sagot sa inyo itong mga sinulatan ninyo?
Lahat ho ng 5 ahensya, binigay ho nila yung amount sa akin. At yun ho ang naging attachment ko sa sulat ko ho kay Chairman Abaya noong 19 September 2011.
Meron po ba kayong copies ng mga sinasabi ninyong sulat na naging attachment ninyo?
Yes, Your Honor.
We have pre-marked, Your Honor, letters coming from the Supreme Court, the Commission on Audit, the Civil Service Commission, the Ombudsman, Your Honor, and the Commission on Elections. May we request that this be marked as marked respectively as our exhibits 105 to 109, Your Honor.
Respectively.
Yes, Your Honor.
Mark them accordingly.
You also mentioned that you wrote a letter to Congressman Emilio Abaya regarding this attempt to put the savings of these constitutional commissions and the Supreme Court in the miscellaneous personal benefits fund. Do you have a copy of this letter?
Yes. My letter actually was requesting him to amend it and not to put it in the miscellaneous personal benefits fund, Your Honor.
We have pre-marked, Your Honor, a copy of the letter coming from Congressman Chanco as Exhibit 104.
Mark it accordingly.
Now, Mr. Witness, what did you do after observing the people who lined up to sign the impeachment complaint?
I left. I left at about 4 o'clock. I passed the session hall. I passed the executive lounge. And after a while, I went home already.
And then when you left, the signing continued?
Yes, Your Honor. Yes, Mr. Senate President.
Of all the people that were in the caucus, they were there waiting to sign the articles of impeachment?
Not all, because some of those I spoke to after the caucus were not also going to sign. So, but when I left, I don't know already, Mr. Senate President, who signed and who did not sign and who came in after. So I can just testify.
How many people did you talk to who indicated that they will not sign the articles of impeachment?
Three, Your Honor.
Three?
Three who will not sign.
3 out of the more than 100 or 130?
Yes, Your Honor.
All
only 3. I was able to talk to 3 only, Your Honor.
All right, thank you.
So what else did you do after this impeachment, the caucus on the impeachment complaint?
I went home.
And then after that?
I slept.
How about the next day? Where were you?
The next day, I delivered a privileged speech resigning from the majority.
This privileged speech, do you have a copy of this privileged speech?
Yes, Your Honor.
And may I see the copy? Can you please tell the court what document you are looking at?
He was looking at this privileged speech.
It's Your Honor, it's the congressional record of December 13. I resigned from the majority and gave up all my chairmanship of the Metro Manila Committee on Metro Manila Development and all memberships in all committees in accordance with the rules of the House. Because
I thought
Yes.
you were reading your privileged speech because he was asking about your privileged speech.
No, I wasn't reading, Your Honor. I was just the way I understood this question, Your Honor, was do I have the privileged speech?
Yes.
So it's here, Your Honor.
And is it on record? What is that document?
It's on record based on the congressional record of December 13, 2011, Your Honor.
Your Honor, we have pre-marked, Your Honor, as Exhibit 112, the congressional record mentioned by the witness as our Exhibit 112. May we request that it be admitted by the prosecution?
Yeah. We admit, Your Honor. We admit, Your Honor.
All right, admitted. So, have you marked it?
Now, after submitting, after giving this privileged speech, after giving this privileged speech, what is your reason now for voluntarily appearing before this impeachment court?
Because I made a privileged speech, Your Honor. So, I have to protect myself. Because people can say later on that ako ay nagtatago sa parliamentary immunity. So gusto ko lang patunayan na lahat ng sinabi ko ho sa privilege speech ko ay kaya kong panumpaan. No? Kaya kong sabihin ulit at kaya kong panumpaan. Para hindi ho masabi na nagsalita ako doon at later on sasabihin kaya mo lang nasabi yan dahil may parliamentary immunity ka no nag-privilege speech ka. So kaya ho ako humarap dito para patunayan na lahat ng sinabi ko sa privilege speech ko ay pinaninindigan ko at pinanunumpaan ko, Your Honor.
Meron po bang pumilit sa inyo na pumunta rito? Meron po bang pumilit sa inyo para magtestigo ngayon?
Wala akong makakapilit sa akin, Your Honor.
Meron po bang sumubok pumigil sa inyo?
Sa diaryo ho, tinatakot ho ako ni Congressman Boyet Gonzales. Ang sabi niya, I will be expelled. Nasa diaryo ho lahat ngayon.
Not responsive, Your Honor?
No, it is responsive.
Let the answer stay in the record.
Ano po ito? Ano
Your
po
Honor,
ito?
sabi niya, I will
ito.
be expelled from the House of Representatives. No? Doon sa aking pagtestigo dito, yun ho ang sinabi niya. So, nung una ho, kung nung sa pirmahan, veiled threat lang ang ginagawa sa amin, ito ho, openly threatening me already na i-expel ho ako.
Mm-hmm. Meron po ba kayong, bukod po dito sa narinig ninyong balita ng declaration po ni Representative Boyet Gonzales, meron po ba kayong nakausap ang ibang kasama ninyo sa Kongreso tungkol dito sa impeachment complaint na ito?
Calling for a hearsay evidence. Ano ba yan?
Yung nakausap po niya?
Sige, basta yung nakausap. Kung may nakausap.
Mandana.
What is the pleasure of the gentleman from Pampanga?
Thank you, Mr. President. Just a clarification at this point, because earlier the Senate President had raised on two occasions as to where this line of questioning will go with respect to the articles of impeachment, specifically Article 2, the SAL-N, bank accounts, dollar accounts, Article 3, the FASAP case, flip-flopping, and Article 7, the TRO on the case of the former President Gloria Macapagal Arroyo. And the chair was kind enough to provide enough the leeway to the defense. So I am asking for the third time, Mr. President. Where is this line of questioning going? And how will we connect this, the testimony of the good gentleman from Navotas to the articles of impeachment, namely Article 2, 3, and 7? May we have a clarification from the defense, Mr. President?
There are 2 points, Your Honor, which I wish to raise regarding the testimony of this witness. First, Your Honor, the testimony to us will tend to prove that the grounds relied upon in the articles of impeachment are not substantial, Your Honor, or do not rise to the level of an impeachable offense. And actually, Your Honor, our second reason is to question the integrity, not only of the complaint, Your Honor, but also of the complainants, Your Honor, so as to create a doubt, Your Honor, to create a doubt which later on may prove to be invaluable to the senator judges when they reach the point where they have to decide whether to convict or to acquit the impeached officer, Your Honor. To us, Your Honor, this creates a reasonable doubt, and this will be material, Your Honor, in the evaluation that will be made by the senator judges when the time comes.
With your, Mr. President, with due respect, we move to strike that from the record because the defense counsel is already testifying as to the bona fides of the 188 complainants when this witness testified only as to matters which are not even connected.
Mr. Congressman, he's just explaining the purpose of the presenting the witness.
Precisely.
He is trying to impugn the integrity of the impeachment complaint that was filed against the respondent. Let the answer stay to the record. Proceed.
Can you please
May we just react, Your Honor?
Yes?
The Honorable Court has already made a ruling that the integrity of the impeachment complaint is beyond review by this Honorable...
Correct. But we will hear them. And the court is intelligent enough to evaluate all of these things.
With that, we submit, Your Honor.
Proceed. The gentleman from Pampanga.
Just a clarification, Mr. President. In such an event, therefore, do I take it to mean that this impeachment court will agree to allow other witnesses to be presented by the defense and have a similar line of questioning? Because earlier, if I recall, Justice Cuevas said that they, when we were having this lengthy discussion on whether or not the affirmative defenses can be presented, and of course the chair ruled otherwise. If I may just finish, Mr. President.
Yes.
So Justice Cuevas said that they have 4 or 5 other witnesses that they will be presenting. Do we take it to mean that we will allow these 4 or 5 other witnesses to likewise?
I will have to hear the testimony of the other witnesses before I can make a judgment. So my understanding is that Congressman Chanco is simply testifying about his own personal experience in the formulation of the articles of impeachment. For what purpose he was introduced is, according to the defense, to establish the integrity and pressure. Am I correct?
Yes, Your Honor.
Attendant to the preparation of the articles of impeachment. Well, the members of this court are intelligent enough to evaluate. They're not bound by the testimony of a witness if they do not believe in the story.
Yes, Mr. President, but perhaps my clarification is that we had a lengthy discussion earlier between the Chief Defense Counsel, Justice Cuevas, and the chair on the issue of whether or not affirmative defenses can be presented in order to question or raise questions about the validity of the complaint.
No, they are not presenting. They are not presenting about the verification. That is just telling the story, the background of how the impeachment complaint was prepared according to his experience. But there are so many people present in that caucus, many people who signed this impeachment complaint, who may have a different experience.
Well, we will submit at this point, Mr. President, to the ruling of the chair, but with the without prejudice to raising some later on, Mr. President, additional issues, Mr. President, on this matter. Thank you, Mr. President.
Thank you. Proceed, Counsel.
Yeah.
Anything more? How long? How long?
That
more
will be
do
my
you-
last question, Your
All right,
Honor.
yeah.
Just the last question. If you have
did I
talked,
talk to?
yes,
Who did I talk to?
regarding the impeachment complaint against Chief Justice Corona.
Who did I speak to?
Yeah. Is there any other congressman that you have spoken to
You
regarding?
mentioned
the signing?
3.
Yes.
You mentioned 3.
Yes.
Do I have to name, Your Honor?
Yes, of course, you have to name if you are going to mention it.
If he wants to name them. You are not bound to name them, but if you want to name them,
I only asked because I only have authority to name one because I don't want to name the others without asking them.
Go.
So I asked one if I could name him just in case I am asked, and he agreed. So I will just name that one if that's okay, Mr. Senate President.
Sure, go ahead.
I spoke to Congressman Dodo Mandanas. He called me up. Congressman Dodo Mandanas called me up on Thursday or Friday. The impeachment was December 12. I resigned December 13. On December 14, Congressman Dodo Mandanas was removed as the chairman of the Committee on Ways and Means. And I think on the 15th or the 16th, he called me if we could have coffee. So,
and what did he tell you?
I told him, anong nangyari? Ano nangyari? Ba't kaya hindi tinanggal? Sabi niya kasi, sa tingin ko, dahil doon sa boto ko, linapitan ko si Congressman Boyet Gonzales. Sabi ko, ano ba itong nangyayari? Ang sabi ni Boyet Gonzales, simple lang to. Kung pipirma ka, kakampi ka ni Pinoy. Kung hindi ka pipirma, kalabang ka ni Pinoy. And I asked permission from Congressman Dodo Mandanas to say that statement, that he told it to me, and he agreed. That is the reason why I cannot name the two others, Mr.
Right.
President.
We have nothing further for this witness, Your Honor.
All right, Cross.
Just a few cross-examination questions, Mr. President.
Are you going to do a cross now?
Yes, Your Honor.
All right, proceed.
Toby, I call you Toby.
Yes, but I will still call you Your Honor because I respect you, Manong Rudy.
Thank you. You are aware that we receive our PDAF through tranches, is that correct?
What do you mean tranches, Manong Rudy?
First tranche, second tranche.
Yes, correct. The first tranche is for the first half of the year, and the second tranche is for the second half of the year, Your
For
Honor.
the second tranche of 2010, which was our first 6 months, did you get all your PDAF?
Completely, Your Honor.
How about for 2011?
For 2011, I have to qualify it, no? For the first tranche, yan ho yung sinasabi ko na delay. Na nakuha ko na yan August 1.
So nakuha mo?
Pero August 1.
Oo nga, nakuha mo.
August 1.
Okay. Right. Nakuha mo.
Pero yung iba ho nakakuha Mayo eh. Manong Rudy.
So nakuha mo. So
pero iba ho yung nakuha ng Mayo, iba ho yung nakuha ng August 1. Your Honor.
How about the second tranche?
Yung second tranche, nakuha ko ho. Sandali. On October...
Okay na, nakuha mo.
Hindi.
My question is, kung nakuha mo.
Hindi pwede mag-explain?
No, nakuha mo.
Hindi, nakuha ko ho.
Yes, nakuha.
Pero yung pecha ho ng pagkakuha ko.
Those who
Ayaw
signed,
malaman.
are you aware that there are 188 complainants in this case? Who signed?
Yes, Your Honor.
Most of them, I presume you know.
Most of them, I know.
Kilala
Yes,
mo, karamihan doon sa 188.
Yes, Your Honor.
Did any one of them ever tell you na ayaw nila yung pagpirma nila?
In confidence, masama ang loob, Your Honor.
Masama ang loob? Ba't may masama ang loob?
Pinilit sila, Your Honor. But in confidence, so I cannot say who told me that, Your Honor.
Okay. I will respect that. That's all, Your Honor.
Just one question, Your Honor, for...
Just a minute, tapos ka na ba, Rudy?
Yes, Your Honor.
Tapos ka na ng
Tapos na po.
Sige. Sino gusto mag-cross?
Just one question on redirect, Your Honor.
Sige.
One question only.
Redirect. Okay.
Mr. Witness, what is the problem if your PDAF is delayed? What is wrong with that?
Malaking problema po yun. Kasi yung infrastructure projects, inaasahan ho yan ng mga constituents natin, madidelay. Yung magbibigay ako ng mas konkretong halimbawa. Lalong-lalo na yung social services kasi dyan ho yung medical assistance. Pag na-delay ho yung medical assistance, paano ho kung may nagkasakit? Hindi mo naman pwedeng sabihin maghintay ka ng 3 buwan bago ka magpagamot. Yung scholarship ho, ang pasukan June. Kung hindi mo nakuha yung PDAF mo ng Mayo, paano ho papasok sa eskwelahan yung scholar mo? Katulad ko na ang PDAF ko nakuha ko ng Agosto, paano ho yung scholar ko ng June and July? So malaking problema ho yun, Your Honor.
No.
Nothing further.
No more?
No more, Your Honor.
Are you true with the witness? Are you true?
Yes, Your Honor.
All right. The witness is discharged.
Mr. President.
Oh.
Senator Miriam Santiago wishes to ask questions.
Wait, let's discharge first the witness.
Yes, to the witness, Mr. President.
Toby, you can now go. You can now go.
Yes, we cannot discharge the witness, Mr. President, because Senator Santiago wishes to ask questions to the witness.
So the lady member of the court from Iloilo is now will now have the floor to ask with questions.
Unfortunately, Mr. President, Senator Santiago wants to ask the questions tomorrow.
Well, anyway, we will discharge Toby now.
For today.
For today.
But
Toby,
ask him to return tomorrow, Mr. President.
Please bear with us. You come back tomorrow.
Tomorrow at 2:00.
All right?
I have no choice, Your Honor.
Pasensya ka na. So, are you presenting another witness, Mr. Counsel?
Your Honor, please, we have requested subpoena for the appearance of these witnesses, Your Honor. And luckily enough, we filed it last week up to now.
Who are these?
At mga kapuso, bago po tayo magpaalam, huling tanong na lang kay Professor Morales. Professor, ano pong masasabi niyo tungkol sa naging takbo ng paglilitis ngayong araw na ito at medyo nakafocus lang tayo dito kay Congressman Toby Tiangco?
Nakita natin ang pag-extend ng lahat ng kortesiya sa isang kamiyembro ng Kongreso. So, nagkakaroon na yata tayo ng preview kung sakali mang umupo at maging testigo si Chief Justice na ipapaubaya din nila kay Chief Justice lahat ng klase ng respeto at yung mga leeway na kagaya ng binigay nila sa kanilang kamiyembro nila ng Kongreso.
Okay. Can we also expect the same treatment for Mrs. Corona if she decides to testify?
Well, that's a different thing. I am not so sure dahil hindi nila kumbaga katropa yan, di ba? And this is a completely different thing. Now, siguro by way of extension to the CJ, hindi naman siguro kagaya ng pagtrato nila sa ibang mga prosecution witnesses. Pero magiging mainit ang ang ite-testify ni Mrs. Corona. So we can imagine how she's going to be subject of clarificatory questioning by our senator judges.
All right, so
tama obserbasyon mo, parang talagang close sila.
All right, so maraming salamat sa legal expert na muli natin makakasama ngayong hapon, si Professor Rowena Daroy Morales. Thank you very much for joining us. We'll see you again tomorrow. Tayo na naman.
At yan po pinakasariwang balita kaugnay sa impeachment trial ni Chief Justice Renato Corona. Ako naman Arnold Glavio.
Huwag po kayong bibitiw sa patuloy na pagtutok ng GMA News TV sa paglilitis ng punong maestrado ng Korte Suprema. Ako po si Vicky Morales.
At ito ang The Chief Justice on Trial. Susunod na ang News TV Quick Response Team.
Pinagtagpo na ang sarap ng Nissin Noodles at katakam-takam na sabaw ng baka sa bagong Nissin Cup Bulalo. Tambalang
na yung 188 congressmen na yan, assuming lang ay hindi binasa, basta lang pumirma, nasa jurisdiction na po na Senado yan. Yan, tulad ko lang po yung impeachment case ni dating Pangulong Joseph Estrada, with all due respect to then Speaker Manny Villar, kahit minadali ng House of Representatives, napunta na po sa Senado yan, under jurisdiction na ng Senado yan. Kahit umayak kami, maglupasay kami sa Malacanang, wala rin kami magagawa dahil nasa jurisdiction na po ng impeachment court yan. So, ang hinihintay po ng tao, Ginoong Lead Counsel on Defense, kung magprepresenta po tayo ng mga witnesses, katulad ni Congressman Chanco, magsasalita tungkol dyan sa mga verification ng complaint na yan, nakakantok na ho eh. Ang kailangan ho namin malaman, kung meron kayo mga testigo, magpapatunay dun sa salin ni Chief Justice Corona. Yun lang po ang hinihintay ko. At yun lang po ang hinihintay siguro ng impeachment court. At yun lang siguro ang hinihintay ng taong bayan. Para kung sa gayon ay makapag-desisyon na kami. Kung ano ba ho talaga ang magiging desisyon namin, whether to convict or to acquit the Chief Justice. Yun lang po. Maraming salamat po.
Thank you, Mr. Senator.
We thank the gentleman from San Juan for the manifestation.
Las Piñas, Senator.
Mr. President, just to set the record straight, the impeachment of the then President Estrada was about 1 month, not 2 days. Isang buwan po yun halos. Nagkaroon po ng hearing sa Senado, 4 na hearings. Sa Senado muna, si Senator Gingona. And then after that, yung I accused ni Senator Gingona. And then, ifinal po yan sa House. Mga 1 buwan po at nagkaroon ng 2 hearing sa committee. Just to set the record straight, 2 hearing po yan sa Committee on Justice. Bago po yan, napakakuha ng pirma ng 1/3. At iba po ang impeachment against a president, a sitting president, because then, ang pipirma po ay mawawala ng anumang benepisyo sa Kongreso. Iba po naman ang pipirma kayo nang naaayon sa gusto ng Pangulo. There is a big difference, Mr. President. It is 100 times different. I've been hearing about this, hindi po ako kumikibo. Now my name was mentioned, I think it's about time I say this. Iba. Hindi po binadali yun. And when you sign an impeachment against a sitting president, you are prepared to lose everything. We heard earlier how Congressman Toby was telling us about he was afraid to lose benefits if he did not sign. But here is the reverse. So, nakaraan na po yan. Ayoko naman pong i-bring up pa yan. Pero nabanggit po, mabuti na rin, gusto ko na rin pong i-bring up yan in this impeachment trial, that there's a big difference. There's a big difference between that impeachment and this impeachment. We were then impeaching a sitting president. When you sign an impeachment against a president, napakalaki pong bagay niyan.
when you sign with the President, wala pong problema yan. I do not want to show how I will vote because I do not know yet. Pero kanina po, wala naman masama mapakinggan siguro yung mga sasabihin ng mga congressman kung gusto nila magsalita. Lahat naman po ng nagsalita sa prosecution, pinakinggan natin, including nasabi yung testimony ni Secretary de Lima na hearsay pero pwedeng ilagay sa record. Sa tingin ko naman wala naman pong masama yan. Napakahirap po na kung tayo ay mag-a-acquit, masabi na nag-acquit tayo maski na walang ebidensya. At napakasakit naman po kung tayo magko-convict na hindi nagkaroon ng hustisya ang accused. Kaya po ako hindi kumikibo, subalit bakit di po natin pagbigyan ng parehong kapanig? May oras po naman tayo. Sana lahat ng maging desisyon natin ay mag-igagalang ng ating mga kababayan na kung mag-acquit dahil walang ebidensya, hindi convincing, at kung mag-convict naman, ay masasabing binigyan natin ng hustisya at pinakinggan natin ang accused. Yun lang po, Mr. President.
Salamat.
Senator Estrada, Mr. President.
The gentleman from San Juan.
Well, although I respect the opinion of my colleague here, Senator Villar, I do not want to belabor the point anymore because it's already useless because this is already history. But what I was not actually complaining is the manner of how fast the transmittal was when it was transmitted here in the Senate. Well, although there was a lot of maybe the hearings that Senator Villar pointed out, yung hindi ko masabi kung railroaded or baka naman magalit na naman sa akin magalit si Senator Villar. I think on my part, I hope he respects our opinion or my opinion that the impeachment case against President Estrada was really railroaded during that day when it was transmitted here in the Senate. And again, Mr. President, I do not want to belabor the point because it is already history. And what I want to hear from the defense is their witnesses who can testify with regard to the sal-en of the Chief Justice. Thank you very much, Mr. President.
All right. The gentleman from
Mr. President,
Las Piñas.
I just stood up just to say that I respect the opinion of my colleague. And I will no longer say anything on this case.
Thank you. Mr. Counsel for the defense, are you ready to present other witnesses?
Your Honor, please. We are sorry to state for the record that we are not ready because these witnesses are not available yet.
All right.
So
then,
we will ask.
There is a request by a member of the court to discuss the matter regarding adverse parties testifying here in a caucus, and we will take that up in a caucus.
Thank you, Mr. President.
Can you present other witnesses before
tomorrow
we settle the issue regarding the testimony of the adverse parties?
We thought, Your Honor, that the two congressmen we have mentioned will be coming over, notwithstanding the fact that the subpoena had not yet been issued. But to our disappointment, Your Honor, they could nowhere be found. So we will ask for another day for them, Your Honor. If we may be able to convince them to come over, even without a subpoena, we will do so, Your Honor, in compliance with the suggestion of the Honorable Impeachment Court.
The Congressman Toby Tiangco came here voluntarily to speak out. I hope the others will do so also, so that we can hear their side.
We are hoping against hope that we will arrive at that point, Your Honor.
Okay.
Thank you.
Mr. President.
Mr. President, may we know the order of presentation of their articles for the defense, Mr. President, so as for us to be able to prepare also for our cross-examination?
Well, the defense may do so if they wish, but my statement, counsel, for the prosecution is that before you started coming here for trial, you should have already some notion of how to cross-examine the possible witnesses of the defense. That's a rule of trial.
But we're just asking, Mr. President,
that means you have a trial brief, how to present your direct examination, your evidence in chief, and how you handle your cross-examination. Point by point, article by article. Because I'm sure you should have anticipated the witnesses that will defend the respondent per article.
we are aware of that, Mr. President, but in the same manner that the prosecution was directed to also present its order of presentation of articles, we're also asking them.
Anyway,
we already did this earlier, Mr. President.
They may, if they want.
We gave them a directive earlier, Mr.
There's
President.
already a ruling.
Yeah.
We would like to. We already gave a directive earlier. The court already gave them a directive earlier to submit.
But I'm just the chair was just reacting to the statement of the distinguished counsel, so that they will know how to prepare for their cross-examination.
Yes,
I'm sure that if I were in your place, by this time any witness that will come to be presented against my case, I'm ready to cross-examine.
Thank you. Mr. President, may we recognize Senator Recto?
Senator Recto is recognized.
Thank you, Mr. President. Thank you, Majority Leader. Mr. President, I do have a copy of the compliance submitted by the defense with regard to the witnesses and documents that they intend to present during the time, and the time has come, to defend the respondent in this case, which is the Chief Justice. And as far as the affirmative defense is concerned, it lists down more or less 5 witnesses. I think we're done with the first. Now, for Article 2 here, assuming we go by the particular order, that was my other question earlier that I wanted to ask the defense, that on Article 2, there are roughly 9 witnesses in the compliance document submitted to the court. So my question now is the intention of for orderly proceeding and for us to be able to prepare as well in this chamber, is it my understanding from the defense counsel that you will continue with 4 other witnesses for your affirmative defense?
No, when we made that announcement, Your Honor, arrangement, we were not clear about the impact nor the coverage of the order of denial or resolution of denial, Your Honor. With this order of denial barring us from presenting evidence on the affirmative defenses, Your Honor, then we will have to change our course of action, Your Honor.
Yes, I understand that, and that's fine with me. With regard to Article 2, there are 9 witnesses listed down here. Do we expect any changes as far as the 9 witnesses?
As of today, Your Honor, we do not intend to make any changes, Your Honor.
So more or less, we will be following the compliance document as far as Article 2.
Correct, that's correct, Your Honor. Thank you, Mr.
And for
Senator.
Article 3, there are only 2 witnesses listed in the compliance.
That's correct also.
And for Article 7, there are only 4 witnesses.
That's correct, Your Honor.
And I take it that at this point in time, no amendments or there are no changes.
No, we have not heard yet the testimony of these people whom we intend to present.
Yes.
So that will highly be dependent on us, Your Honor. If in our appraisal there is no necessity or further imperative necessity to call other witnesses, then we will not do so.
In total, Mr. President, just for the food for thought for the impeachment court, there are 15 witnesses listed. Thank you, Mr. President.
Thank you also, Mr. Senator.
So, What is the pleasure now of the House?
Mr. President,
Majority Floor Leader.
may we go now to other matters?
Yes.
Yes, Mr. President, Attorney Vitaliano Aguirre, a private prosecutor, was cited for contempt during our last hearing. The penalty to impose upon Attorney Aguirre was agreed to be discussed in caucus. Related thereto, Attorney Aguirre has filed a withdrawal of his appearance as a private prosecutor. Also, there is a pending motion of Senator Trillanes to rule on the participation of the lawyers in a press conference regarding allegations of offer of 100 million pesos to each senator judge. The issues have been fully discussed, so the impeachment court is ready to rule, Mr. President. We would like to ask for your ruling.
Well, as I said previously, the court finds it prudent, because of the attendant circumstances, to impose a penalty of admonition upon Attorney Vitaliano N. Aguirre II, in view of the fact that he already filed a withdrawal of his appearance as a private prosecutor in this impeachment case. And in addition, I think he made an apology. However, the explanation and apology from on the other hand, there was also this motion of Senator Trillanes on the participation of certain members of the certain lawyers in a press conference regarding allegation of offer of 100 million to each senator judge. And I think the court feels that in effect there is an implied suggestion that there is a quid pro quo in the votes to be obtained from the members of this court, which this court considers an indirect contempt of the court. And so therefore this court is constrained to cite the one of the lawyers of the defense, Attorney Roy, for contempt. The penalty to be imposed will be subject of a determination in a caucus of this court. So ordered.
I thought it's either life or life imprisonment or death penalty.
That will no, we do not. We do not go that far. We will.
I just said it in jest, Your Honor. I apologize.
I understand, but that could be misunderstood by the public, and I hope that, with due respect to the defense, this court must assert its dignity and honor in this proceeding, and we are going to think about the penalty to be imposed upon him commensurate to the degree of the...
Isa nga po sa naging highlight nitong impeachment trial sa ika-27 araw ng pagdinig laban kay Chief Justice Renato Corona ay ang pagharap ni Navotas Congressman Toby Tiangco bilang kauna-unang defense witness. Pero bago yan, sa unang bahagi po ay sinubukan pong i-propose o igiit ni Defense Lead Counsel Justice Serafin Cuevas na i-dismiss na lamang ng impeachment court itong kaso laban kay Chief Justice Renato Corona. Bagay na kinontra naman po ni Presiding Officer Senator Judge Juan Ponce Enrile. At magpapatuloy po ang pagdinig dito sa impeachment trial. Ako po si GMA dito ang News TV Quick Response Team, sumusugod kahit saan sa ngalan ng katotohanan. At tabayanin niyo po ang Balita Pilipinas ngayon.
Magandang gabi po. Nagpapatuloy pa rin ang ika-27 araw ng impeachment trial ni Chief Justice Renato Corona.
Nauna nang sumalang si Navotas Representative Tobias Tiangco bilang testigo ng depensa. Isinalaysay niya mga dahilan kung bakit hindi siya lumagda sa impeachment complaint. Balikan po natin ang paglilitis sa Senado.
Noted.
May we ask Sergeant at Arms to make an announcement, Mr. President?
Please all rise. All persons are commanded to remain in their places until the Senate President and the Senators have left the session hall.
Move to adjourn until 2 o'clock in the afternoon of Tuesday, March 13,
2012. March the 13, 2012.
Ayan, katatapos lamang po ng impeachment proceedings para sa araw na ito.
Ika-27 araw yan ng impeachment proceeding labang kay Chief Justice Renato Corona. Samantala, partner, dakuha natin iba pang balita sa ibang parte ng bansa.
Iniimbestigahan naman po sa ibang balita, iniimbestigahan naman po ng otoridad ang sanhi ng pagbagsak ng helicopter ng militar sa Kitcharao, Agusan del Norte. 7 ang sugatan sa nasabing insidente.
Magsasagawa raw sana ng rescue operation sa mga sakay ng bumagsak na helicopter para sa mga sundalong nasugatan sa engkwentro sa New People's Army. Makibalita tayo sa telepono kay Donna Timbal ng GMA Davao.